Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people? And people is misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
No more. See, because he's the guy.
All right, welcome back. Welcome back to the Court of Public Opinion. I am the Recovery Addict. A happy Martin Luther King Day Monday to you today. We've got a little bit before court begins. We're waiting for them to finish up their lunch. And so in the meantime, in between time, we have a little bit of entertainment for you. Before we do that, let me first just give a big shout out to Special K, who was first in chat today. Congratulations, Special K. Because you were first in chat, we're going to send it to you to internet ownership. That's it. Everything IP related worldwide is now your responsibility. Please maintain it, fix it, keep it working, do all those things so we don't have to. Appreciate that. Make sure you help yourself to a commemorative plaque commemorating this occasion. You can download it for the low fine of 50 cents on the shopping page on the YouTube channel. All right, you're going to do great, Special K. You're going to do just fabulous. You're going to be fabulous. All right, we're going to jump to an oldie but goodie court case, which we've never watched this one before on this channel. This is an older one, but it's a soft sit, and it was like one of the first times this judge ever live streamed, I think. So, and he got a soft sit for day one. It's probably what made his decision to live stream. But let's see, we're gonna get that going here right here. Ooh, it's a little loud. Let's see what we got here. We'll be jumping to court as soon as they come back from lunch. The defendant's not there yet. Where's he at?
All right, good afternoon. We are on the record in 53rd Circuit Court for the County of Sheboygan. We are providing public access to our docket this afternoon, both in the courtroom and also online. Our first case this afternoon is People of the State of Michigan versus Trevor McLeod. It's filed 23-6748FH. Counsel, you want to state your appearance, please?
Anthony Julian on behalf of People.
Okay, Mr. McLeod, are you present, sir? You want to come on up to the table here?
I want to reserve all my rights.
That's fine, and I'll. Sorry. Okay. All right, so Mr. McLeod, this is the time and date scheduled for what's called for a circuit court arraignment. The case having been bound over to this court by the district court. So you're here representing yourself today, is that correct?
Yeah.
What's that?
Yeah.
Okay. So I'm required by law to make sure that I've taken an initial waiver of your right to counsel in this court. So I covered a pre-trial hearing in the district court, so we talked a little bit about this, but now it's up in my court. So you've got two constitutional rights. You can have you have the constitutional right to be represented by an attorney, and if you wanted to have an attorney at public expense and qualified, to have that. You also do have the right under our Constitution to represent yourself. Obviously, you can't do both things at the same time. So do you understand your right to a lawyer, including a court-appointed lawyer?
I understand.
Okay. And do you wish to represent yourself instead of having an attorney?
Yeah, I'm here by special appearance, and I will be representing myself.
Where's this website?
I'm required by law, before I accept that waiver, to do a couple things. One, advise you of the maximum penalties that you could face for the charges that you're in my court for. Resisting, obstructing conservation officers is a high court misdemeanor punishable by up to 2 years in prison and or $1,000 fine. There's a habitual offender second notice that's been filed by the prosecutor, which would make that a felony punishable by up to 3 years and or $1,000 fine. and marine safety operating while intoxicated is a misdemeanor punishable by up to 93 days and or 100 to 500 term. Do you understand the maximum penalty for the charges against you?
Well, I don't even really understand why I'm here, honestly.
Well, okay. Well, that's fine. Do you understand the maximum penalty that I just explained to you?
No. So,
hold on. I can't let you represent yourself until I establish a couple things.
Well, I need to establish a couple things too, honestly.
Hold on. Well, I can't let you represent yourself until I establish a couple things, or I'm going to be in trouble.
Okay.
Do you understand that the maximum penalty that you could face for the charges that you're here for is up to 3 years in prison and or $1,000 fine?
I don't understand the nature and cause of the action against me. So
what is it that you don't understand? Do you not understand how long 3 years is, or how much the fine is that I've articulated? Can you tell me what it is you don't understand?
The nature and cause of the action against me because you don't establish jurisdiction.
That's not what I'm asking you right now. Well, I'll let you place whatever objections you want on the record, Mr. McLeod. I promise you that. Okay. Can we just go one step at a time? Is that okay? Sure. Okay. So one step at a time, I need to establish that you're exercising your constitutional right to represent yourself validly. So for me to do that, somebody might decide they want to do that and they really don't understand what's at stake. So I have to establish on the record that you do understand what's at stake.
Well, I think you have to establish on the record first that you can have jurisdiction. That's been a question. It was questioned in preliminary hearing. It was never addressed.
I'll address that today.
Well, it has to be addressed before anything can move forward, honestly.
Okay, so you want me to explain to you why I have jurisdiction?
Yes.
Okay, let's do that.
Jurisdiction it's under.
Sure. Okay. This court has subject matter jurisdiction over crimes punishable by more than a year as the court of general jurisdiction under the Michigan Constitution of 1963. The people voted to ratify that Constitution. That is the underlying law of our sovereign state of Michigan.
Okay, so is that a jurisdiction under criminal? Or is it military?
Yeah, it's a criminal charge against you, and I have jurisdiction over that.
Okay, so the Constitution of the United States only grants you two criminal jurisdictions. One's common law, and one is military tribunal venue under Article 1, Section 8, Clause 17 of the Constitution. Which of these two criminal jurisdictions is that?
You're not in federal court. It's not a federal crime you've been charged with. You've been charged with violating the law of the state of Michigan. And, hey, what's going on over there? What are you doing, sir?
I'm trying to make sure that this is going live. It's not happening. There's something messed up with your film, and I'm trying to straighten it out. I was just checking to see if it was recording or not.
Sit down. Sit down. You're disrupting the courtroom.
Sorry, sir.
The IT guy?
It's live.
It's live. I'm watching on my phone. It's
Any more
working.
disruptions, I'm going to ask you to leave. All right.
So, common law?
You're in a state court. You're charged with violating a law of the state of Michigan.
Is that a statutory jurisdiction? What is it?
Yeah, it's a statute. And this court is duly authorized under Article 6 of the Michigan Constitution. So that's my jurisdiction. So now I need to make sure that you're establishing your right to represent yourself. So do you understand the maximum penalty that you could face if you're convicted as charged? 3 years in prison or $1,000 fine.
Well, I have another question because the statutory jurisdiction doesn't exist under the Constitution. So in order for me to defend myself, could you please tell me where the published rules of conduct are for criminal statutory jurisdiction, or where I can find the nature and cause of this jurisdiction, or how this information exists?
No, I don't even understand what you're asking.
So you're saying this is a statutory jurisdiction under what? The statutes of Michigan, correct?
Mr. McLeod, I've told you what my jurisdiction is.
General jurisdiction.
The people of the state of Michigan voted to convene a constitutional convention in 1961.
Sure.
There was a constitutional convention in 1961 and 1962. They proposed a state constitution.
He's getting
The
the full
voters
history.
of the state of Michigan ratified that in 1963. Article 6 establishes the judicial power. And the circuit court is a court under that judicial power, Article 6 of the state constitution. The legislative power is exercised by the House of Representatives and the state Senate. They have passed statutes that the governor has signed. The prosecutor's office is alleging that you have violated those statutes. And so you're here in my court. I have subject matter jurisdiction over those crimes. I have personal jurisdiction over you because you've been alleged to have committed them in our county. That's my jurisdiction. So, Mr. McLeod, do you want to represent yourself? Do you understand the maximum penalty that you could face of 3 years in prison and or $1,000 fine?
He doesn't have a response for that. He's like, oh crap, now what? Where's my script? 1 second.
I can see why his attorney would Drew. Oh, shit.
Hang on. Someone in the prosecutor's office is not muted. I'm going to remove you from the meeting at this time.
Oh.
Prosecutor's office is generally allowed to attend, to observe. They participated. I'm removing them from the hearing.
That's the funniest thing I've ever seen.
Mr. McLeod, do you understand the maximum penalty that you could face?
Oh, shit.
1 second.
Prosecutor's
so
office just
enforcement of mere statutes,
zoinked.
judges of all courts do not act judicially and are thus are not protected and qualified by limited immunity. That's Owen versus the city. I just want to state a few things for the record since you're claiming this is a jurisdiction under statutory law.
Hang on. Mr. McLeod, can we back it? Look at me for a second. Can we talk here?
I've challenged subject matter jurisdiction and nothing can go forward until that's addressed. You're saying
I did address it and I denied your objection. I have subject matter jurisdiction.
Doesn't exist under the Constitution.
Your objection's noted. All right. So, Mr. McLeod, do you understand? Let me explain to you.
Sure.
Sometimes, as I said, people might want to represent themselves, but let's say they have limited intellectual capacity and they don't understand what's going on. I have to establish that they know what's going on before I can allow them to represent themselves. I'm required to establish, do you comprehend, do you know the maximum penalty that you could face if you're convicted as a result of this charge? 3 years in prison or $1,000 fine. Do you understand that, Mr. McLeod?
So I'd like to state for the record that
Mr. McLeod, stop.
Court can be
Stop, Mr. McLeod. If you don't understand it, I'm going to revoke your right to represent yourself and have an attorney represent you because I can't establish that you know what you're doing. So do you know the maximum penalty that you would face?
I've challenged this court's jurisdiction. You haven't established it yet. You said you have a statutory jurisdiction which doesn't exist under the Constitution. I'm trying to figure out where I stand with this. So I can't answer any of your questions until you answer some of mine.
That's not how it works. Are you refusing to answer my question?
No, I'm
Then answer it. Do you understand the maximum penalty that you face for this charge?
So judges who become involved in enforcement of
Mr. McLeod,
statutes,
I have other matters. Mr. McLeod,
agency.
you know, I understand you want to object to things, and you're going to be allowed to object to things. Okay, sure. But we have to do things one step at a time. And I do have other cases today. I'm not going to entertain this for like a whole hour. I've got other cases going on. If you want to dig in your heels and just make this real complicated or real difficult, we could do that, and I can hold you in contempt, and you'll go back to a jail cell for a while.
I don't wish to be held in contempt. I just wish to exercise my Sixth Amendment right.
That's fine.
And
so before I can let you under,
I can cite laws that will show you that the exercise of a right can be converted into a crime. I'm trying to understand the nature and cause of the action against me. You're not clarifying enough to where I can comprehend it, as you say.
You comprehend the maximum penalty that you would face.
I'm not answering any of those questions until you establish that this is a court of the Constitution, has jurisdiction under these jurisdictions.
I established it. I told you. You might think I'm wrong, and you can appeal.
There's no such thing as a statutory jurisdiction.
Mr. McLeod, let me make this simple for you. Do you ever watch, let me make this simple for you.
Looney Tunes.
I'm going to ask you this question one more time. One more time.
Okay.
Two things are going to happen. You are either going to answer my question, or I'm going to hold you summarily in contempt, and the court officer will bring you to a jail cell, and we'll talk about it tomorrow. You understand that?
So,
Mr. McLeod, two things are going to happen. You're going to answer my question, or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges. All right,
Mr. McLeod is in contempt of court, taken into custody.
Really? That's it. Protecting my rights is fucking job. This isn't true. You guys are
follow unconstitutional orders.
Following law orders. It's not constitutional at all.
Mr. McLeod's in contempt was sentenced to 1 day in Mr. McLeod, your sentence is 1 day in jail. We'll reconvene tomorrow and get you
This is
notice.
about the Constitution. I did nothing wrong except to question exercising my rights.
Bye-bye.
Mr. Mathis and Mr. White.
Well, that happened. Now let's address that issue of the prosecutor burst in.
Good afternoon, Mr. Mathis. Can you hear me?
I can, sir.
I think we're done.
All right. This is Mrs. Ross Mathis, file 23-6738FH.
Yeah, we're done with that one. Josh, thank you for that little that short little. That was terrible. That was terrible. Of all the frustrating guys, the judge probably explained subject matter jurisdiction better than I ever heard it explained before in any court, even going so far as to citing the dates and the occasions that the people voted and ratified the state constitution. It was extremely, extremely thorough. Defendant would have none of it. As soon as the judge got off his script, all he could do is go back and start at the beginning again. And ended up with a day in jail. I don't know how that one ended. Maybe there's some other videos that will tell us how that ended. But that was the lady that blurted out. The lady that blurted out, that was on the Zoom call. The prosecutor's office had connected to watch. And a lady in the prosecutor's office is watching this as this is going down. And she says out loud, not knowing that she's not muted, well, I guess I can see why his attorney withdrew. And I'm sure as she's watching, she realizes that her microphone is on, and the judge like, hey, and she's like, oh shoot, only she didn't say shoot. But the judge kicked her out, said normally you're allowed to watch on Zoom. I'm kicking you out of this one. But that was really funny. All right, we are about to get back to court in let's see, where are we at? We going to 2? I think we're going to 2. We're going to 2. We're about to get back to court. We are expecting the closing statements in the Tennessee versus Chen case to begin momentarily. I feel really small in this little box. Let me fix that really quickly. Run to A. Whoop. I'm feeling bigger now. All right. Kelly, that was pretty funny. That was pretty funny. She wasn't wrong. No, she was right. She said the quiet part out loud is what she did. Elizabeth, I agree. The right thing for the judge to do is to rule that since he does not understand, he's not fit to represent himself. Remove that right from him. If nothing else, at least he would have a competent attorney to defend him, even though he probably would not work with the attorney. I guess the next step would be possibly a competency exam to see if he is mentally sound, if he's there. I don't know. Yeah, but that game is so old. I don't know what website, what book. Where do they find this? Because they all have the same script. They're like, there are only 2 powers written under the Constitution. Where is there a website? Would somebody just link me to the pro se transcript website, so I can just, I don't know. I'd like to tear it apart myself. I know it's out there. They're finding it on the internet somewhere. It's got to be out there. Probably Reddit somewhere. Pro Se for Dummies. There's a Facebook group. If there's a group, I would just like to see like the video posting of the guy who's like, I tried it and it worked for me. I want to see that video. The guy's like, the guy who goes into state court, challenges and says, this is Admiralty Court. And the judge is like, by gosh, you're right. There is a fringe on the flag. I guess you get to go free. I didn't realize all this time. I didn't have authority. I just want that one case. If somebody could link that to me, that would be great. All right. Maybe if you Google subject matter jurisdiction, that's a great place to start. You have to pay for a copy of their manual. I'm sure it's got like a 5-star review as well, right? Like, this covers everything you could ever need to defend yourself in court. Never serve a day in jail, no matter what your crime. Yeah. What happens is charges get dropped for other reasons, and the civets think it worked. They cite that it was their intellectual prowess that did it, not just the fact that the judge says, I would rather retire than face this guy one more time on this stupid interaction over a parking ticket. Yes, I'm in blue today. I'm in blue. I like him in blue. What was he trying to say? He was trying to say that the court does not have jurisdiction under the Constitution. And they always cite the U.S. Constitution for this. And oh, hey, hang on, we got a call. Hello. Oh, wait. I need to plug you in. Hang on. Hello, you're live on the air. Hey, Thomas, how are you doing? Happy birthday.
I'm good. Thank you so much. I figured I'd call and help you fill a little airtime.
Awesome.
I've got you on in the garage. I can't be in chat because it's up on the TV.
Are you sitting there just watching the snow outside? You guys have some terrible weather in Texas.
So southern Texas, big time. It's freezing where I am, but we're going to be in that kind of mid-level bubble where we're going to see zero precipitation at all.
Oh, nice.
It's very, very weird because usually when Texas gets it, it's us, but it's going south and not us. So, but that's good. Yeah. So I had to make a quick comment.
Yeah.
That was really, really funny from this morning. When you were doing the happy birthdays and said, go get your free pancakes here. And then you said, or Weather Watch's house for smoked pancakes.
Uh-huh.
My wife was dead asleep, not moving, not completely asleep. She belted out laughter when she heard that in her sleep, and you say that, and woke up.
Oh my goodness! I don't know if you can smoke pancakes, but I figure if there's somebody who could find out, it would be you. But.
Well, as soon as she stopped laughing, I said, "You know what? I might try that. See how that turns out."
It's like smoked blueberry pancakes. There's got a ring to it.
Yeah.
How's your birthday going?
It's been good. It's been good. Just dropped my car off to get a little work done to it. I am now in the garage. I'm upgrading the TV and the location in the garage. That's a birthday gift to me because the smoker still resides out front, and that's where I am every evening.
You haven't been able to talk your wife into letting you bring it inside.
Actually, I did steaks and mac and cheese on the smoker last night, and it was about 16 degrees. And I was just sitting in the driveway.
It's frigid.
But it was cold. But no, I'm excited because then I can watch the Dallas Stars while I'm smoking dinner or lunch or whatever I'm doing. And it's just time. I spend probably 80% of my time in the garage and or driveway with detailing our cars or just piddling, really, making excuses. But
that's awesome. That's awesome.
Little birthday gift. Walmart had their name brand TV on sale. Very inexpensive, but I've had really good luck with them. So,
awesome. But that's a good deal. Well, that is hilarious to hear that I woke up and missed Weather Watch with the smoked pancakes comment. But
she died laughing.
That's awesome. Well, I'm glad that made her chuckle a little bit. That is great. Thomas, have yourself a fantastic birthday. I appreciate you. One of our great mods. Good friend. He's my podcast partner as well. If you want to hear Thomas and I interact about things that are not relevant and sometimes are really funny, Thursday night's the night, 8 p.m. right here on the channel. So.
Absolutely. We have a good time. So thanks so much for the birthday wishes. And for those of you in chat, I have seen the birthday wishes from this morning and just a bit ago. Like I said, I'm watching on a TV, so I can't be in chat. So I thank you all very, very much for that. I do see them, and that's well received. So it's been a great day, and I appreciate you all.
Happy 21st birthday. Have a good one.
Yeah. Wink, wink.
Yeah. Thanks, Thomas. Good to hear from you. We'll see you.
All right. We'll see you. Bye.
Oh, that's funny. That is funny. But he could make a good smoked omelet. Thomas is becoming like a phenomenal chef with that smoker. He posts the pictures, and I swear he's stealing them from Pinterest. Other than the fact that I can see that it's his smoker. Like I think he's going to publish a book eventually. Like He's doing great, but love to hear that he's getting a little birthday present and going to be able to watch the game while he's smoking food. So, all right, we are a couple minutes overdue. The judge said we were going to be back about 15 minutes ago. We're not yet back, so we're just hoping that. We're getting some motion here. Maybe it might just be a minute here for them to come back. When they do come back, we are expecting the judge to tell the jury to sit quietly and listen to the presentation of the prosecution and the defense. Although this is not evidence, it will sum up all the evidence and the theories of the prosecution and defense. And then that will also, when they're done, it will kick off the time for the jury to begin their work as they deliberate back in the deliberation room. Only 12 of the 15 jurors will deliberate. And I think we've got, eight men, 7 women currently sitting on the jury. A couple of those are going to be excused and be told, hey, thanks for leaving your family and everything. You served a great purpose, but we don't need you any longer, hopefully. So they are on a long lunch. Jury's had a late lunch. All right, the jurors did get the instructions. They were listening the same time we were, listening to the judge lull us into sleep with his captivating reading voice. Nanny B says, Recovery Addict got my husband a Traeger. Now everything Weatherwatch has done, my husband would say, yeah, can do that. I need to get new tires on my car. Took my car in for a tire rotation, ended up needing brakes and rotors. Plus some filters and oil housing replacements. At that point, you pretty much just getting a new car, waiting for the call to pick up. Hope your car gets done fast, Weatherwatch. I was driving yesterday. We had a little bit of rain yesterday. I was driving out on the freeway, and there's a spot in the road where the tire marks have made sort of like a divot in the asphalt. And I was doing freeway speed, which is about, I was in a 60, so I was doing under 70. But I'm driving along, and my tires just lined up perfectly with that, right as there's a little curve. And that whole front end, it just picked up. There was no contact. It was full hydroplane. I could probably need better tread. These slicks on the front are not cutting it anymore. So I was supposed to change out those tires before we drove all the way out back west across the country and back. And I didn't, and I still haven't. So it's definitely time. They're due new tires. We changed out the back ones, but not the front. Those divots are called potholes, but they're like long rows of pothole. There's one continuous pothole. And for those asking, I had a salad for lunch, a delicious salad. Did cheddar mozzarella cheese, some Black Forest diced ham. I was going to do avocado, but the avocados we have are still like about a week away from being ripe. So I've got to wait for those to sort of ripen on the counter or in the fridge. Some croutons, and I used ranch for the dressing. Poor road maintenance. What is road maintenance? What is this road maintenance of which you speak? You're supposed to repair the roads periodically? I don't think they do that here. Sure you didn't have a sandwich? I hear nothing of salad. No, I did. I had a salad. It was iceberg lettuce. Hello? Just trying to connect. Somebody's trying to call me. But call failed. Never mind. Not sure why they're taking this long. Unless the judge was taking a little more time deciding that issue that they sort of announced. And I heard poorly. It was poor audio. But there's some issue with either or on some of the charges. I think it has to do with littering. Either the abuse of a corpse or littering. It's going to be like an either or situation. All right, did they do closings? No, they're about to, Irish Princess. That's what we expect in just moments. Road maintenance is where they close down several lanes for months and then don't fix it. Oh, okay, we do that. We do that. Don't think he's taking a plea here. I don't think the state's going to offer him one. They were literally trying to eliminate one of the lesser includeds, which would mean the state's willing to go more of an all or nothing type approach. A salad on bread is called a sandwich. I didn't have any bread for lunch other than the croutons. You have 2 seasons, winter and construction. Why stop during the winter? I guess the snowplow hitting the cones would probably be an issue. Why would he take a plea deal when he has all the lesser charges? Right. Lesser charges are really in a case where you've got the defendant who is like as guilty as they get. Like his lawyer's already admitted he's guilty. In a case where the evidence is that strong against the defendant, lesser includeds benefit the defendant. In a case where there is not much evidence, where weak evidence, lesser includeds harm the defendant because you're more likely to get a compromise verdict with lesser includeds. Trauma Llama, I cannot click on your link. Or your words, I apologize. Had 2 Oreos and coffee for lunch, says Karina. In the candy bar analogy, a Hershey Kiss is equal to littering. The Hershey Kiss is way down there, yeah. Sarah, we've got a lot of business done before that. A lot of argument, a lot of discussion, a lot of the formalities. We got all of the jury charge done. So we're doing really well on time. We should just have closings here any minute now. It's crazy this hasn't happened yet. It is just a little bit above freezing where I'm at. Definitely doesn't feel like negative 15. We will do a poll on how long deliberation will be. We usually do that right as the jury goes into deliberation. That's our traditional time when we do that. So right at the close of the closing arguments. I do apologize. I still don't have the ability to put the timer up on screen without getting rid of something like, I don't know. Well, maybe I can do it with... Might be able to do it. I've got a GoPro feed on 7 that I don't need. So if I were to take that, might be able to do this. The littering charge is offensive. Yeah, when you start counting someone's body weight in pounds of litter, it doesn't sound right. It doesn't ring right. Court said they expected the trial to last until Wednesday, so right on track of counting verdict deliberations. Poor jury decided to work today and ended up sitting in a room all morning and afternoon. Better than just sitting in the hotel, not able to talk to each other about the trial. Here we go.
Per our discussion in chambers, I will reread the use of the corpse, where it's just one figure.
Apparently the judge did make a change to the abuse of corpse instruction, so he's going to reread that.
So, well, I can say in chambers we discussed how to proceed. And I'll say, I'll just go through it and I'll say, is this correct? In front of me?
Will you verify that all parties agree
Yes.
to that solution?
Defense attorney can't see the judge. Still can't see. He's like, I still can't see. Just waiting for the jury. So sadly, we thought we were done. The judge has a little more reading to do. It will just be that last part, the abuse of a corpse, possibly the littering as well. So we're gonna hear that, and then we'll start with the closings. It looks like the state has a demonstrative or a video to go along with this. I will warn you, however, there is a chance that the camera will observe on that screen some of the images that we did not broadcast during the trial intentionally, that the judge has told us not to show. We may not get warning this time, so please be mindful that there may be some very disturbing images shown as part of this trial. They are associated with this trial and pertinent for the jury to consider, but just be aware of that. I have not heard about the time limit for closing. TK Sewing Machine and Repair, welcome to the gallery. TK Sewing Machine. Machine and repair. That's an in-demand skill. There's a company here not far from me called Quilt Lizzie that sells sewing machines and embroidery machines, and they wanted to hire me to do sewing machine repair, even though they knew I'd never done it before. They were so desperate. So they said, we'll train you. Yeah, I told them they couldn't afford it. Like on singers and stuff? That'd be cool. We are already up to 421 likes. Thank you very much for that.
Sure, as I'm sure you gathered, that the jury instruction we worked on was a fluid project. Kind of tweaked it all the way up, including when I was reading it to you, so I had to change one of those subsections. I should say over the break, we talked with parties, and there's going to be a modification to the abuse of corpse jury instruction. The littering aspect will not be part of it. It's just one theory that the state is alleging happened. So I'm going to reread that to you just so there's no confusion. Any person who commits the offense of abuse of a corpse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant physically mistreated the corpse in a manner offensive to the sensibilities of an ordinary person, and 2, that the defendant acted without legal privilege, and 3, that the defendant acted knowingly. In deciding whether the act was offensive to the sensibilities of an ordinary person, the jury must avoid subjective, personal, and private views and evaluate the sensibilities of a hypothetical average adult person, applying the collective view of the adult community as a whole. Ordinary person means a person of ordinary care and diligence in relation to a particular thing. Legal privilege means a particular or peculiar benefit or advantage created by law. A person acts knowingly with respect to the nature of circumstances surrounding a result of his or her conduct when the person is aware of the nature of the conduct, that the circumstances exist, or that the conduct is reasonably certain to cause the result. The requirement of knowledge is also established if it is shown that the defendant acted intentionally. A person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause of the result. Again, for the record, this is something that the state has agreed to. Is that correct?
Yes, Your Honor.
It's something that the defense has agreed to. Is that correct?
Yes, Your Honor.
Remember, what is said in closing arguments is not evidence. You have already heard and seen all the evidence in this case that you may properly consider. During the closing arguments, the parties may mention points of law or refer to these instructions that the court has given. However, the law that you must follow in reaching your verdict is the law that the court has given you in these final instructions. If there is any difference between what the parties say about the law and what the court has said in these final instructions, you must follow the court's instructions. With that, since you've already heard all the evidence in the case and your notes are to help you in understanding the evidence, at this point you must all put your notepads under your chair. You're not allowed to take notes during closing argument because it's not evidence.
I don't like that rule.
But you may refer to your notes and your stay ready to close.
Yes, Your Honor.
D, prosecution liability.
If they put wheels on that, it would be quieter. Mr. Moyles goes first. Hopefully we can hear everything. There's no mic. Crap. This would be terrible.
What's in the bags is a matter of perspective. For one person in the courtroom, was contained in Exhibit 138-6, found on the banks of the Tennessee River in Hamilton County, was an inconvenience. Something that needed to be gotten rid of, discarded like a piece of trash. Something that you don't care about. But to other people in the courtroom whom you've heard from today, it's something, not today, but over the course of this week, something to be cherished, something precious, something that you'd be willing to go to the ends of the earth to find and bring home safe. What's in the bag? Jasmine paste. The court has instructed you on the law. And this case really boils down to premeditation. What is premeditation? Well, it's a conscious decision, a choice to engage in murder. The court told you already that it need not exist for any definite period of time. Not an hour, not a day, not a minute, not even a second. And as we talk about premeditation, I'm showing you what's already been admitted into evidence as Exhibit 129. It's a video, you've seen it, and I think it bears seeing again. But not for the reason that you're thinking. It's 5:59 p.m. on the 23rd of November, 2023. You can see on the screen Mr. Jason Chen wheeling this suitcase towards his Toyota Camry in preparation for driving to Suck Creek Road and dumping Jasmine Pace to sit until found by law enforcement on December the 1st. The video stops here. We've all approached a traffic light. The light was turned yellow. You can see it here. As someone approaches this traffic light, they have a choice. You step on the gas, Do you step on the brakes? You consider what time of day is it? Are there pedestrians? What's the traffic look like? Are you running late? Is there a need to get where you're going quickly? All things that your mind processes in an instant. You make the conscious choice to either hit the brake pedal or to go hammer down. And as we'll see, silver car, when faced with that decision, just like Mr. Chen, accelerated, kept going, didn't stop. I want you to keep that in mind as we start going through the proof. What opportunities did Mr. Chen have during this to take the off-ramp away from violence, away from murder, away from 60 stab wounds? And it's important to know the timeline. And how long does it take to choose to kill Miss Jasmine Pace? Mere seconds. Our story starts at 11:27 p.m. when Miss Jasmine Pace leaves her parents' house. You've seen the pictures of it. She drives from her residence to Jason Chen's apartment at 110 Tremont Street. We can see her arriving in 11:42. A minute before, her My Chevy app shows that her ignition turns off in her car. And people asked in the case in chief, who is the person walking towards the door of the apartment? The state's position is that that's Miss Jasmine Pace. The last time she'd ever be seen alive. Then at 2:11 a.m., the defense called a witness whose name is Courtney Paglino Brewer. She was awoken by a scream. Lasted several seconds, she described. She heard footsteps chasing away from the bedroom towards the front door. She heard a female voice that she described as sad but assertive. At the tail end of an argument is what was said. And then she hears the front door slam to Mr. Chen's apartment, not the interior door. She told you she knows what the interior door sounds like. She knows what the front doors to the apartment sound like when they slam shut. And it was the front door to the apartment. She hears sounds of walking, but what's very important is she doesn't hear glass breaking, bottles hitting the floor, nothing. 2:15 a.m., Miss Katrina Pace sends a pin of her last location to her mother. Miss Jasmine Pace sends it to Katrina. Now, there's two options, sure. But circumstantially, we know that it's Jasmine that sent that message, because there's only two options. It's either Miss Jasmine Pace in a cry for help, letting her family know where she is, or it's Mr. Jason Chen using the phone, sending a message to Katrina Pace, Jasmine's mom. For what purpose? To get caught? We know he doesn't want that to happen, based on everything else that we see after. So by process of elimination, it's Jasmine Pace. At 2:31 a.m., Mr. Chen's downstairs neighbor, Courtney Paglino Brewer, hears a television turn on in Mr. Chen's bedroom. At no point does she describe sounds of toilets flushing, person retching on the floor. No, she hears what? Garbage disposal? Washing machine. That's at 3 a.m., about 1 hour after the murder. We next move forward to 4:04 a.m., about 1 3/4 hours or 1 hour and 45 minutes after the murder. And what starts happening? Jasmine Pace is dead, but her phone starts springing to life. Exhibit 126 shows at 404 through 428 a series of messages. I ask for you to compare Exhibit 126 to 139. So what? We scroll over. Mr. Chen is now attempting to access Jasmine Pace's bank accounts. How does he know that? Because he's got her bank card right there. He has unfettered access to her property that she brought with her. Phones, driver's licenses, credit cards. Moving forward to 9:52 a.m., now 7 3/4 hours or 7 hours and 45 minutes after Miss Jasmine Pace was murdered, we get to the Tinder. We get to the Tinder data on Mr. Chen's cell phone. And what does it show? Oops. What's it show? I guess we're dating now. Ask yourselves, is that the mindset of a person who's stricken with grief? Or is it the mindset of somebody who has zero remorse, who does not care, that would take a body, put it in garbage bags, load it into the suitcase, load it into their car, drive it out to the wilderness, and dump it on the side of the road? Which is consistent? Your common sense tells you that it's the latter. Shortly after, at 10:29, we see Mr. Chen emerge from his apartment for the first time on the 23rd. He's wearing a very distinctive hat. Anything goes. This hat's important. Probably wondering, why would we introduce a hat into evidence? It's because, ladies and gentlemen, this is the one article of clothing that through it all never leaves Mr. Chen's person. We can see here on the Arctic video starting at 10:29, Mr. Chen come out of his apartment wearing all black. When he steps into the sunlight, you see the red and white of the Anything Goes hat. See it right there. He then gets into his car, and he goes where? To the Walmart. Curious thing, though, as Mr. Chen rounds the corner of Tremont Street onto Fraser Avenue in the North Shore of Chattanooga, he's by himself. There's no one in the front seat. So what? We can see the Anything Goes hat. We can see Mr. Chen. We can see his car. The so what is that at 10:42 a.m., both his phone and Jasmine Pace's phone arrive at the Red Bank Walmart just a mere minutes away. And what does Mr. Chen do? He goes into the Walmart. We can see him wearing all black in Exhibit 18. Wearing, you guessed it, Anything Goes. Mr. Chen then selects various items while he's shopping in the Walmart, but not before he sends this. Good morning. Slept like baby? Made myself a matcha. In an attempt to create an alibi, he's not there. He's somewhere else. You must ask yourselves, is that a sick joke? Slept like baby? Sent to the person that you just stabbed 60 times? Is that the conduct of somebody who doesn't know what they're doing? They're just frantic? Or is it methodical? Does it show a desire in their mind to try to divert attention away from themselves? He uses a photograph to place him at Starbucks rather than Walmart, where he's buying cleaning supplies, towels, Band-Aids. He checks out at 11 o'clock a.m. and then immediately goes Sup Creek. The location that Miss Jasmine Pace was ultimately found inside this suitcase being indicated by the red pin with body location in the middle. You can see that he's going to the west and to the south of Sup Creek Road, looking for a good spot. And he found it. He returns home at 12:38, carrying his Walmart bag, wearing his anything goes hat, where he stays for several hours and begins the laborious project that is cleaning up the copious amounts of blood that had been spilled in his apartment. Then at 12:43, after he's been home for just a few minutes, some interesting activity starts on Miss Jasmine Pace's phone. At 12:23, on the 23rd of November at 12:43 p.m., he starts trying to get into Jasmine's iCloud. Why? Why? So he can have unfettered access to her digital files, so that he can start creating a further alibi, so that he can begin the process of impersonating his victim to make it appear as though she's still alive, to buy time. That's not the conduct of somebody in a frantic panic, doesn't know what they're doing. That is the conduct of somebody who is cold and calculating. We then see Mr. Chen again later that afternoon at 1:36. This is when he takes the trip from his apartment at 110 Tremont Street and goes to Walgreens the first time. You'll note that his appearance has changed. See how he's wearing a light-colored top and black pants? Different than what he was wearing at Walmart, but again, he's wearing his favorite anything goes hat. One of the jury questions was, what is the significance of item 153? Why was it so important to collect a quarter zip sweatshirt? Most importantly, why was it so important to collect this quarter zip sweatshirt? As you'll see here in a little bit, ladies and gentlemen, it's got a very distinct look. Mr. Chen will wear a black shirt under it. You'll see very clear that he continues to wear this, including when he eventually goes to dump the body. That's the reason. We'll set this over here next to the anything goes hat. Make a note of the V produced by the opening of the neck beneath the head. We can then see Mr. Chen drive off, again wearing his red hat and his gray hooded sweatshirt. You've seen the videos. Mr. Chen buys what at Walmart or Walgreens? More cleaning supplies. Isopropyl alcohol. He returns home, but leaves again at 2:56 p.m. The purpose of this trip is it's an extended one. He's going to scout Sup Creek Road the second time that day. He's again wearing the gray hooded sweatshirt and the anything goes shirt or hat. But at 4:03 p.m., while he's still out looking for a place to dump Jasmine Pace's body, he sends this message. Hey, are we still good for dinner tonight? A message which shows is read by Jasmine Pace. I remind you where Mr. Chen is at this moment in time. Where the body is found. Again, slept like baby. He's still good for tonight. Is that the conduct of somebody who's frantic or someone who's depraved? Then we fast forward to 5:59. You've seen it. Mr. Chen emerges from his apartment with a suitcase. Watch as he tips it over. How heavy it is. Almost pulls him to the ground. Watch as he struggles. Here we go. Tipping it over. See it? Watch as he struggles to go around the corner towards the light post. Right there. Because it's not clothes. He's not going on some trip. It's a person. It's Jasmine Pace. 98 pounds. Soaking wet. 5 foot 2 inches tall. In a rolling suitcase. He then drives past. Again, wearing his anything goes hat, his gray shirt. He heads to Sup Creek, disposes of Jasmine Pace, and goes to Walgreens again. But not before he makes a pit stop. He makes a pit stop at Walgreens. Remember Mark Hamilton, the cell phone forensics expert, when he testified? He said that Jason Chen's indicators were red, Jasmine Pace's were green. Miss Pace, despite actually being on Sup Creek Road in this suitcase in the cold November night, her cell phone in Mr. Chen's possession ends up at Walmart. Why? It reconnects to the network. Why would Mr. Chen do that? Remember that read receipt? He's now turning on strategically his phone and her phone to create instances where it appears as though she's online but he's nowhere around. His phone goes dark, her phone turns on. Her phone goes dark, his phone turns on. It's manipulation of digital evidence to try to distance himself from the fact that he's disposing of the body. And we know this because at 6:49 p.m., Miss Jasmine Pace's cell phone with the IMEI number disappears. It's off the network. The SIM card is out of the phone. The SIM card that's in evidence in 167-2. SIM card which was extracted and shown to belong to Miss Jasmine Pace. The defendant enters the Walgreens, again wearing this gray hoodie, completely zipped down, large V on the neck, with a black shirt under it, white shoes, and his ever-present anything goes hat. He heads home. But he's got a problem. He got rid of the body, but there's another big piece of evidence sitting in the parking lot of his apartment. It's Jasmine Pace's car. So, at 8:26 p.m., he dons a disguise. Think about it. You've now seen his goings and comings at Walgreens, Walmart, the Arctic videos. Does he ever wear a face mask? No. He wears the face mask because he knows where Jasmine's car is located. It's right next to this room. But he knows that that room has a Ring camera. You've got all the Ring videos and evidence, which predate November the 23rd. You can see him looking at it. He knows it's there. So he's got to hide his appearance. Again, to try to cover up his misdeeds. Ms. Pace's car then at 8:27, 1 minute after the Ring video, car starts up and we have hard acceleration twice during a trip from 110 Tremont Street to 900 Mountain Creek Road. Why? He stayed with Tinder that it's because he's not familiar with this vehicle. He doesn't know how it drives. He doesn't know how the accelerator works. And we can see him in his disguise, put up, blue surgical mask, driving Jasmine Pace's car. He does drop it off at 900 Mountain Creek Road. You've seen that happen. You've then also seen the ride share come and pick him up 9 minutes, 8 minutes after 8:41 p.m. And then you've also seen this. Oops. Jason Chen getting out of the car, wearing his plaid shirt over his white hoodie. The white hoodie in Exhibit 152. Exhibit 143, this plaid shirt. And he goes into his apartment. Now, how might somebody who's upset about what they have done react? How? I can tell you what Mr. Chen did. Less than 1 day after stabbing a girl 60 times in his apartment, 6 hours after taking a body and dumping it on the side of the road, Mr. Chen says to his buddies, "I'm getting on in like 5 minutes." The entire conversation is there. They're talking about playing video games. Says COD, Call of Duty. After engaging in actual physical violence, he goes online to get some more. Then we fast forward a couple of days, and Mr. Chen does something somewhat unexplainable. He takes Jasmine Pace's cell phone, takes his cell phone, removes the SIM card from his phone, and puts it into Jasmine's. And he begins his cell phone data from T-Mobile, Exhibit 136, shows that where he had been using an iPhone XR, he now starts using Jasmine Pace's phone. Again, why? Because he now will have unfettered access to all of her social medias. He can start posing as her more effectively, communicating with the family, giving the impression that she's not dead so that they don't come looking for her to buy more time to clean up his apartment. So let's talk about the crimes themselves now that we have the timeline down. Abuse of a corpse, as the court has instructed you, is treating a body in a manner that offends the sensibilities of an ordinary person. Wrapping wrapping a person in 3 garbage bags, putting them in a suitcase, driving them out into the wilderness to unceremoniously plop them on the side of the road on an embankment down by a river is offensive. Plain and simple. No reasonable person thinks that's acceptable. Especially once you know that the family's looking for her. Sure, he dumps the body on the 23rd, but when the family's looking for him, mum's the word. In fact, even after the family breaks into the apartment looking for her, nothing. First-degree murder. In order to convict the defendant in this case, you have to find several things. First, the venue that this crime happened in Hamilton County. You heard the testimony of multiple witnesses. Mr. Chen's apartment, 110 Tremont Street, specifically apartment 210, is located on the North Shore community of the city of Chattanooga. Chattanooga is in Hamilton County. We have proven venue. Next, we have to show that Jason Chen is the person who committed the crime of murder. Next, we have 3 elements. That Jason Chen unlawfully killed Jasmine Pace, that he did it intentionally, that he did it with premeditation. Again, going back over venue, you've seen it, you have a map of it. North Chattanooga. We've kind of gone over this a little bit, but I do think it's important to point out because it goes directly to the heart of identity. You can see it in Exhibit 129, 21, 129, and when you watch Exhibit 129, the Arctic video, you'll see it yet again, especially the black, dark V-neck right there. That's Mr. Chen pulling that suitcase. The suitcase that contained Jasmine Pace's body. So we can point out all the similarities. It's like a fingerprint. He's got his anything goes hat, his black shirt under his zip top with his black pants and his white man's shoes. Oh, which are in evidence as well. Exhibit 157.
Surprised they didn't tear open the evidence.
We know that this is Mr. Chen and not some other individual wearing a anything goes hat with a black shirt and a quarter zip, because when he enters the Walgreens and buys some Bounty paper towels, he uses a credit card. That credit card has numbers on it. Those numbers match the wallet collected from his Nolensville residence where he was staying with his parents. And you'll see that it's a match. Furthermore, the garbage bags that contained Jasmine Pace's body that were found inside the suitcase have not one, but 2 different fingerprints belonging to Mr. Chen. We also heard from Detective Crawford during his direct examination about slippage injuries to Mr. Chen's hands. All of that circumstantially shows that Mr. Chen is the same person that we see on the videos, is the same person in possession of the physical evidence in this case. So let's talk about intentional. 60 stab wounds. 60. Not 1, not 2, not 4, not 20, not 30, not 45, 60 individual stab and is-sized wounds were on Jasmine Pace's body at the time she was examined by the medical examiner's office. That means stab, action 1. Removing, action 2. Each stab in and of itself consists of 2 distinct movements. The movement plunging the knife blade in and the movement removing the knife blade out. Back in, out 120 times. He had to move his body to be able to inflict the number of injuries that we see on Jasmine Pace's body. Dr. Cogswell, our medical examiner for Hamilton County, opined that the cause of death was multiple stab and incise wounds. So let's talk more specifically about the premeditation in this case. Using the understanding that we had earlier regarding the example with the traffic light, that it can be formed in an instant, there's evidence of preparation, the number of injuries inflicted upon Miss Pace, as well as his conduct after the fact, all show that this was not some act of somebody who didn't know what they were doing, but somebody that had a plan, carried it out, and carried it out well. You gotta ask yourself, if Miss Jasmine Pace is in the fetal position, if she wasn't moving, like the medical examiner told you, if the incised wounds are on her left arm, right shoulder, no significant injuries further down, head and neck, but only on the right side, the chin and the eye, what does that tell us? What about the lack of stab and incise wounds to the left side of the body? What about the lack of stab and incise wounds to the front of her body? What does that tell us? It tells us several things. Excuse me.
I got on no source.
Big pardon?
I got on no source. Just let me know when you're ready. I'll remind the media of the court's admonition not to broadcast.
Did they just show that when I looked away?
Okay.
Ready?
Yes, sir.
I'll see you later.
Yes, sir. I warned the audience, I warned the media. It's consistent with Jasmine Pace being found when she's being stabbed. If someone were stabbing a person 60 times, we would expect them to try to get away. But what if they can't? What if they can't because their right hand is chained to their right leg, their left leg chained to their right elbow? Makes it difficult to run. Makes it difficult to do anything. Dr. Cogswell told you that she was stabbed in the fetal position 60 times. We'd also expect that if she's being attacked on the right side of her body, that she might try to defend herself with both hands. There should be injuries on both hands. Instead, what we have are injuries to the left hand, no significant injuries to the right hand. That's consistent with her being in the fetal position with a hand unable to move on the ground. It's consistent with exactly what we see on the screen right there. Her being handcuffed. We also see additional injuries on Miss Pace at the time of autopsy. We don't know what caused them. We can't tell you. But what they are consistent with, according to Dr. Cogswell, is the application of pressure of some kind around the throat. The application of a large amount of force to the rib cage and some bruising to the nose right next to the right eye. And you also have bruising to her right arm. Let's talk about the restraints for a minute. The handcuffs and the shackles. Primary interest are these shackles. The defense insinuates that the shackles were not placed on Miss Pace before the stabbing took place. Why? Because if you shackle somebody and then stab them, well, that's taking a step to accomplish what you do. You're confining somebody, you're making it easier to stab, but there's a problem with that. Dr. Cogswell told you that dead people don't move, right? Makes sense. Don't know that it would require a medical expert to say that, but it is a truth. These are the shackles. Ankle, arm, connected at the elbow. Why would Jason Chen take the time to apply a set of broken shackles to somebody? He wouldn't. But dead bodies don't move. You know what do move? Somebody that you're trying to stab 60 times. They don't move much if they're shackled. They don't move much if their right hand is handcuffed to the inside of their right ankle. But ask yourselves, why do the handcuffs not break? Well, you get a whole lot of momentum. Your leg and your hand are tied together. You can't really kick because you can only go as far with your leg as you can with your arm. But guess what you can do with these shackles? You've got more length to work with to build up momentum and snap the chain. Not enough for Miss Pace to get away. No. Not enough for her to get away. She had two sets of restraints keeping her right arm down there so she couldn't fight back with her right hand. Only with her left. You can see it right there. It's broken because Jasmine Pace fought back. It's broken that because when Jason Chen put those cuffs on her, she tried to get away, but was only to break free with one set. Couldn't break from the second. That's all it took. It's all it took to keep her in one place so that he could inflict a total of 60 stab and incise wounds on her little body. That's all it took. Having her in the fetal position with one arm chained to her right leg on the inside. And let's think about it. Why on the inside? Not on the outside. If it is, as the defense would have you believe, that Jasmine Pace was cuffed up while she was dead, right? Why on earth would they apply one shackle to the elbow and the other one to the left leg? She's not moving. She's not going anywhere. You'd make it so that it matches, right? You want her to be in as tight of a package as possible to fit into this teeny little suitcase that's not designed to hold a person. She's not moving. Cuff the hands together, shackle the two legs together, and pull them together. You wouldn't go haphazard, right hand to right leg, and then attach a cuff here and attach the shackle to the left leg. That's indicative of she doesn't want to be shackled. He's just slapping the shackles on whatever he can find, whatever he can get his hands on. It's been insinuated that this was a crime of passion. Chen blacked out, didn't know what he was doing. 60 stabs, wakes up, what have I done? I want you to remember something. Dr. Cogswell told you that the injuries inflicted on Miss Pace, Jasmine, were from two categories: antemortem, paramortem. He emphatically said, I found no evidence of postmortem injuries. Remember that testimony? You mean that a crazed individual who doesn't know what they're doing knows the precise moment to stop stabbing? Or would somebody who's acting under some kind of a passion that just keeps stabbing, they would keep going after they're dead? He used the precise amount of force necessary to accomplish his goal, and then he stopped. That's evidence of premeditation. It shows that he knows what he's doing. It shows that he's in control of his actions. And we can see it there in 204:11. That's a paramortem. I want you to think about it. If you're stabbing somebody and you've slit their throat, severed their jugular, the epiglottis, so that she's now inhaling and choking on her own blood, aspirating it into the lungs, creating that, I think it was leopard print pattern, cheetah print, I forget. But the pattern inside the lungs, that's not a quick death. It's not an instant kill. Remember the questions were asked of Dr. Cogswell? That would immediately incapacitate her, wouldn't it, doctor? Not necessarily. So then you move on to somewhere else, another vital organ. The lung. The head. But you want to know what happened with the lung? Well, the knife blade broke off. It made his job much more difficult. We know that some of the wounds, like the through and through of her hand, the through and through of her neck, and the one that broke off in her back, all had to happen ante-mortem with the knife blade still intact. From there we can't say, but what we do know is that not a single one came after she was dead. What are the odds? And during Dr. Cogswell's testimony, there was a question from the jury, and it was a good question, a very good question. How many of them, of the wounds that you saw, were downward? But remember, Dr. Cogswell always talks and describes in standard anatomical position. Up means towards the head. Down means towards the soles of the feet. Right means towards the victim's right hand, and left means towards the victim's left hand. Front, the front of her body. Back, the back of the body. But remember what Dr. Cogswell also said, that he believed that she was in the fetal position, which could be accomplished in only two ways. Standing on the flat of her feet like this, or on her side on the ground. And if we're talking about on her side on the ground, the standard anatomical positioning gets tricky. You'll have the autopsy report back there. And a question was asked, were any of them upward? Any of the wounds indicating upward? And that doesn't necessarily mean up towards the sky. It just means, for instance, in this case, an oblique stab wound on the right web of the neck penetrating upward through muscle only is generally in that direction. So as you read the autopsy report, remember, upward doesn't necessarily mean that she was standing. What it can indicate is that she's on the ground. It's just a nice angle traveling from one direction to the other. Now, we've already talked about this, but after he stabs Miss Jasmine Pace, after he disposes of her body, he's disguising his appearance. That's a higher level function of Mr. Chen's brain. He is thinking about, I don't want to get caught, so what can I do to avoid detection? He's got to clean his apartment, which he's already started doing, but how can I not be recognized when I'm going out disposing of various pieces of evidence? So he disguises himself. And just if there's any doubt, on the bed, this hoodie was collected. You can see it's stark white pull tabs. And this shirt. And when you watch the video frame by frame, you can see the pattern. And it's a match. Being left in the crime scene. Another interesting thing that he does is he starts changing his habits. When you see him check out at Walgreens, when you see him check out at Walmart, when you see him running around, he's using his phone as his wallet. But, inexplicably, when he gets to Nolensville, his phone, which he uses as his wallet, is now inside a red jewelry box in a bedroom. And he's transitioned to an actual physical wallet that heretofore on the videos you've not seen. Why? Because he's concerned he's now being tracked. He can't take his phone with him, or it might give away where he is. And he stages the scene. We know he stages the scene based upon the physical evidence. The giant saturation stain on the left side of the bed, on the north wall of the bedroom, the oil stains along the east wall. But when law enforcement arrived, his bed has moved. It's now up against the north wall, covering up the stain. Don't forget, Exhibit 72, crime scene photograph, shows indentations in the carpet consistent with an item having been recently moved. What item? Well, there's a nightstand that's the same general shape in the corner next to the bed. Also, in Exhibit 117, you can see Mr. Chen with his bed very clearly centered on the east wall. Why would he move his bed? To cover up the large blood stain on the carpet, where Miss Jasmine Pace, to quote Dr. Cogswell, leaked. This is circumstantial evidence, personified. Do you see the black stain on the right side of the left shoe? It's right there. Go through the crime scene photos. He likes Vans. It's a pink pair, got another white pair in boxes. Where's the rest of the knife? Never been found. We don't know where it is because Mr. Jason Chen, after stabbing Jasmine Pace, disposed of that too. And obviously we've already talked about this, the body. We've also talked about the manipulation of digital evidence. About that as well. Everything he does It's calm, it's collected, and most importantly, it's rational. Everything he does is to a point, and that's to escape capture. Everything he does leading up to the attack by shackling and restraining Jasmine Pace is to make it easier to accomplish the act itself. That is premeditation. It doesn't matter that he didn't have it written down on some sheet of paper. Today will be the day that I kill Jasmine Pace. All that matters is he took steps to commit the murder. He committed the murder. And during the commission of the murder, you mean to tell me that during any one of those 60 stabs, he never once thought I should stop? No. Like the car approaching the yellow light, it was hammered down. Keep going. Don't stop. The defense's theory is that this all happened in the bedroom. This was been insinuated. They're expert. Something big happened in the bedroom. The defense postulates that the blood in the bathroom is because Mr. Chen crawled on the floor and took his shirt off. That's how the blood got there. Remember that question being postulated to the defense expert? It's possible. Is it reasonable? We'll talk about it. Their own expert described the collection of evidence as he was testifying on direct examination yesterday. CPD, crime scene, did a good job collecting things with the knowledge that they had going on. Their own expert said that. I didn't ask that question. He just offered it to you. That was his opinion, unsolicited. He talks about crime scene contamination and how footprints through blood can move blood from one part of the apartment to the other. But he then, on cross-examination, admits that in order for there to be blood soaked through the grout, it has to be a large volume, sitting there for a while. Right? You mean to tell me that when the Pace family conducted their frantic searches of Mr. Chen's apartment, you mean to tell me that when the Chattanooga Police Patrol officers walked through, they trampled through enough blood to soak through grout and produce that pattern on the underside? That's unbelievable. It's incredible. And it's unreasonable. Now, he did tell you that what we have here in Exhibit 179-6 is an impact mark. Remember his testimony about that you can infer the direction based upon the angle of the tail of the blood drop, that as it impacts the surface, it creates kind of a teardrop shape with a little dot. See the little dot? And then from that, you can infer the direction from which the blood came. And in this case, he agreed. When shown this photograph, 179-1, that where the blood came from that's over 6 feet off the ground was, lo and behold, the red area outlined here in the bathroom, not the bedroom. He also is of the opinion that despite the blue star lighting up like this, that's just transfer. Even though that's in the same room where we see the impact mark with direction indicated. His opinion is that the attack happened in the bedroom and that this is the result of massive bleeding. He says that he could see in these photographs that there are scuffs on the wall, and that's indicative of something happening there. Remember that testimony? Scuffs on the wall. He tells you that he can't see drag marks, but he did recognize a blood trail going from the bathroom past number 6 under the bed to the large saturation stain that we saw in the preceding photograph. He also tells you that he could see in his photo what he believes to be 3 fingers. I don't know about your fingers, But when we put that picture up on the projector, I ask you to agree fingers aren't in a straight line. How perfectly straight were those lines of the fingers? I ask, isn't it possible that it was the folding of the sheet over on top of each other and a transfer in that manner, not a fingerprint? You couldn't say. In light of all of that, counsel asks, would that blood have been transferred by Jason? I don't see how it would have. Remember, he was asked about the attack and would that have created a large volume of blood, a large amount of blood? And he said, yes, it would have gotten everywhere. Jason's arms, his chest, his shirt, even the back of his head. Well, if that's the case, remember what Dr. Cogswell said when he was describing the position of Jasmine Pace's body on the large carpet. He said that her head, when we had it splayed out here on the floor, and remember the two straight corners, north wall, east wall, north wall, east wall, okay? Head was here, posterior, buttocks here, legs tucked up. Remember that explanation? If that's the case, well, that's not much room in which to stab someone 60 times, is it? It's also curious.
I like that in that graphic image warning.
How would you be positioned to be able to even inflict those wounds in that little area? It's not reasonable. The explanation makes absolutely no sense. I mean, don't forget, it's an attack that literally broke the knife blade off. A violent attack, creating blood that would have covered both the victim and Jason Chen. But ask yourselves, if that headboard was up against the wall, meaning this is the side of the bed exposed to that violent exchange, where's all the blood? All we have are these little red spots. A couple small limb transfers. Where is the blood on the maroon sheet that was pulled all the way down?
Cameraman's earning his pay today.
Ask yourselves, if the attack severed the ulnar artery on the hand that's free, you mean to tell me that Dr. Cogswell, who described arterial bleeds as spurting, that there's not blood everywhere, just in a little puddle? Where's the blood? On the floor, no doubt. We'll agree to that. Where's the impact stains? On the bed, the wall, door frame, the molding. Where's the blood? Dr. Cogswell told you in his testimony, follow the blood. And it just doesn't follow. Where's the sheet? If Miss Jasmine Pace was stabbed 60 times within a foot or so of this bed and that sheet, in the manner described by Dr. Cogswell and their own crime scene expert, it would be soaked. But it's not. All we can see are some red stains in the carpet. Rather, ladies and gentlemen, the proof in this case, the scientific proof, even the testimony of the defense's own witness, Mr. Lawrence, establishes that the more violent, aggressive, physically impressive acts occurred in this room, the bathroom. In that area right there. I want you to think about this. in order to soak through the grout that we see in the preceding photographs. That would have required a large puddle for an extended period of time. The blood stain at Exhibit 6 is consistent with blood running off the end of the tile and beginning to soak into the carpet. No doubt the defense expert is correct. Carpet is absorbent. And it started wicking the blood off of the tile floor before Mr. Chen had an opportunity to soak it up. Whose blood? TBI tested it. It's Jasmine Pace's blood. Jasmine Pace's blood found on the threshold in the transition from the bedroom to the bathroom. The impact marks lead back to the large puddle of blood, to the large puddle of Jasmine Pace's blood. And oh, by the way, 159.12 and 159.13. Remember he said there's an impact mark on the threshold of the door in the bedroom, and it ran down and then puddled a little bit? That blood will do that. It'll impact, it'll drip, and then it will stop. And we got that on the bathroom floor. But hey, it didn't happen there. It's what their expert thinks. Despite the fact that the bathroom lights up like this, he says it's all contamination. That's his opinion. All of this is contamination. He said it over and over and over and over again. Contamination, contamination, contamination. Everybody's contaminating. I'm contaminating. Everyone's contaminating. You want to know where the Paces, the police, the crime scene units aren't walking with their feet? How about the doors? It's not contamination. That's Jasmine Pace's blood, because that's where Jasmine Pace was murdered. Further proof of a cleanup as if you need it. He's buying paper towels. He's buying cleaning supplies. And yet the only thing that we can find, despite Mr. Lawrence, a nice gentleman, okay, saying that Mr. Chen didn't do a thorough cleanup job, yes, he did. All we have is blood and grout and a discoloration stain from where she was brutally murdered by Mr. Jason Chen. Further proof of it. Further stains in the grout. Let's talk about voluntary manslaughter. Defense has said provocation. Provocation, provocation, provocation. Based on what evidence? Courtney Paglino Bruin said she heard him argue. You've seen an awful lot of arguing in this courtroom over the course of this trial. An argument is not an excuse to murder somebody. Just because you have a disagreement with somebody and they're yelling, that's not adequate provocation to lead an otherwise reasonable person to act in an irrational manner. Mr. Chen is always a rational person in everything he does, whether it's posing as the victim online, whether it's sending the family messages, whether it's turning her phone on and off, whether it's using her phone to try to hide his activities. Everything's with a purpose, including chaining her up. There's been absolutely no evidence other than there's a disagreement. She sounded sad. The female voice sounded sad but assertive. And she screamed. provocation. It's a nothing. It's just not there. What would cause a reasonable person to act unreasonable? It was posited earlier that it was a wine glass. Where? Miss Brewer didn't hear crashing. She didn't hear breaking. All she heard was running away from the back of the apartment towards the front. Is that consistent with the story that we were told earlier? No, it's not. It's consistent with Miss Jasmine Pace trying to get away, being stopped, being restrained, and then being murdered in the room that, guess what, is in between the bedroom and the front door. Mr. Chen was able to stop her before she got out, and that's where he handcuffed her, and that's where he started stabbing her. Did she bleed a lot in the bedroom? Absolutely. Absolutely. But even when you were shown the carpet with the giant saturation stain, you can't say that's Jasmine Pace. You remember that question being asked over and over? Then whose is it? Every explanation that has been given for Mr. Chen's conduct up until this point has been disproven. Remember, don't forget, ding ding. Ding ding. Ding ding.
Ding ding.
That's what set Jasmine off. But you've seen the tender records. And it's not there. What this shows is a person who may have had an aggressive emotion during the attack, no doubt. Every murder is aggressive. Every murder is emotional. That doesn't mean that it was provoked. Ladies and gentlemen, Mr. Chen unlawfully killed Miss Pace. He acted intentionally. The number of wounds, his restraining the victim before the attack, his conduct after all shows calm reflection on the task at hand. And that's why he's guilty of first-degree murder.
I'll sit down.
Go find him guilty for snuffing out Miss Jasmine Pace's life on the 23rd of November, 2022, at 2 o'clock in the morning. Thank you.
We should not have breaks here. We should go back to back to back. Defense. Static. Ooh. Miss Morrison's doing the closing. Please,
Ladies and gentlemen of the jury,
stay by the mic.
on behalf of Jason Chen and his defense team, we appreciate your attentiveness during the course of this trial. This has been a difficult trial. Jasmine Pace's life was taken on November 23rd, 2022. Jason Chen did that. Jason Chen and Jasmine Pace have been in a relationship on and off, as you heard testimony, for about a year. On November 22nd, just before midnight, Jasmine Pace came to Jason Chen's home at 110 Tremont Street, apartment 210. It's undisputed. What happens between 12 o'clock and 2 o'clock? There's no proof of it. But we do know just after 2 o'clock in the morning, Courtney Brewer was awakened. She was awakened by what she described as a female screaming. What we know is that Courtney couldn't describe what was being said. She couldn't say to you, she couldn't answer any questions about what the argument was over. She described it as something that you couldn't decipher. Emotions are up, pulses are up, everyone's aggravated. Jason Chen's scared. Jasmine's upset. Jason's upset. And Jason killed Jasmine. He got a knife, and 60 times Jasmine was stabbed.
It's a strange closing for
That
defense.
hasn't been disputed by the defense since the first day of this trial. What's been disputed is the state's allegation that this is premeditated. You as a jury have the most important job. You're going to retire to a jury room, and you're going to be looking at all of this evidence. You're going to be looking at all of the testimony, recalling the testimony that you've heard from all of the witnesses. Investigator Crawford, Dr. Cogswell, Courtney Brewer, CSU investigators. You're going to be going through mounds of evidence, days of testimony. And like the general asked you during jury selection, you get to use your common sense. You get to apply what you know to the facts and the evidence that's been given to you. What we know is that from just after 2 o'clock in the morning, everything that Jason did showed that there was no plan. It showed that he wasn't acting rational. Rational people don't shackle individuals and put them in garbage bags. They don't shackle the individual, put them in the garbage bag, and put them in a suitcase. They don't go the next day to Walgreens and Walmart to get cleaning supplies. They call the police. Everything that Jason Chen did was disgusting. It's unacceptable. That's not refuted by the defense. The state would like for you to believe that everything that Jason did from just after 2:18 in the morning until he was in Nolensville was part of the plan. He left breadcrumbs everywhere he went. He got Jasmine's phone. He used her phone. The state has asked you to believe that Jason had full control of her phone from 2 o'clock on, but they don't want you to think for a moment that he yet again made a mistake. He tries to not share a location, stop sharing a location, and drops a pin. They want you to believe that Jasmine was shackled when she was being stabbed. Dr. Cogswell was asked very specific questions, questions that you can remember. You can look back through your notes. You can recall his testimony and discuss this among yourselves. There were no ligature marks on Jasmine's wrist. There were no ligature marks on Jasmine's ankles. There were no cuts. There were no bruising. The state would like for you to believe that's because she couldn't move. She couldn't break the shackles. She couldn't break the handcuffs. The reason they aren't there is because they were not applied so that Jason could stab her. They were applied so that he could fit her into garbage bags before putting her into a suitcase. If the state was able to establish that she was cuffed and shackled, there's your premeditation. They don't have that. You don't have that for the proof either. What you have is the state's argument to you today. That's the theory you should believe. And their own expert refutes that. No defensive wounds, no ligature marks, no bruising, no cuts. An individual that's fighting and tied would surely have that. Jason is charged with 2 counts: abuse of a corpse, first-degree murder. When you're in this jury room, you're going to be tasked with finding him guilty of an offense beyond a reasonable doubt. What is that? Reasonable doubt, beyond a reasonable doubt, is going to be the elimination of any doubt that Jason Chen committed these offenses. Let's put them side by side. The abuse of the corpse charge. A reasonable person would not believe that it's acceptable for Jason to put Jasmine into trash bags after she's been shackled, put her into the suitcase, drive her to Suck Creek, and discard her. No reasonable doubt would a reasonable person have. That's not acceptable. That's unlawful, and that he's committed that offense. When you're in the jury room, though, do you have that same confidence related to premeditation? Do you have the same conviction that Jason knew what he was doing, that he intended to do this, and that he had the plan to do it? The law is clear. We're not asking you to believe that Jason had hours, days, months that he's planned this out. But you have to know with moral certainty that he had a moment to reflect and that he didn't. It's the state's burden to show you that he had that moment of reflection and that he chose to disregard and to continue to engage in acts that killed Jasmine Pace. Ladies and gentlemen, that's not here. You've heard from Courtney Brewer about the yelling, something that she can't even describe to you what was being said. Movement throughout the apartment. Jason's actions from that point forward, well, are not acceptable or adequate. If you believe that Jason was provoked to a point of being in fear or terror, then you're going to be looking at the jury instructions specific to voluntary manslaughter. I'm going to pull up on the screen here what specifically you need to look at in the jury instructions regarding premeditation. When you're dealing with premeditation, and I'm going to read this to you, but you have the ability to read it yourself. It's a premeditated act that is done after the exercise of reflection and judgment. Not one, but both. An exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act. What we've heard for days is everything Jason has done after. This is not you going to the jury room and determining that there's post-meditation. It's premeditation. Everything that Jason did before Jasmine's death. It's not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The state says each of those actions, 120 movements, Jason should have had the ability to reflect. They haven't shown that he did. What you need to look at also is in Dr. Cogswell's testimony. He talked about the injuries that Jasmine sustained. He talked about how they were centralized, how there wasn't a pattern, that it seemed erratic. It seemed as if someone was in a state of excitement, a state of passion. When you're looking at the lessons that the judge has already instructed you about, when you go into second degree or voluntary manslaughter, when you find that the state has not met their burden to prove premeditation, you're going to be looking specifically at the distinction between what is second degree murder and what is voluntary manslaughter. specifically voluntary manslaughter, requires that the killing result from a state of passion. The state's witness talked about this. They talked about the individual that inflicted these wounds being in a state of excitement or a state of passion. Right here, in your jury instruction. That is something for you to consider. It does require that there has to be a state of passion that's produced by adequate provocation. You heard yelling from the floor below. That was enough to wake an individual up at 2 o'clock in the morning. So loud that she couldn't even make out what was being said. There's an argument. Provocation. When you're looking at the next step, it would lead a reasonable person to act in an irrational manner. The state would like for you to believe that he was cool, calm, and rational. Irrational people do the things that Mr. Chen did. On the next slide, when you're trying to determine what the state of passion is, passion means human emotions such as anger, rage, resentment, terror, similar emotions which render a mind incapable of cool reflection. If you find that there was provocation, that you believe Ms. Kruger, that she heard a female screaming, so loudly yelling that nothing could be made out of what she's saying. Anger. Jasmine is angry. Jason. We don't hear that Jason's yelling back or that Jason's screaming at her. We hear that a female is yelling. If you find that there is a specific issue of whether or not Jason could have been in a state of passion, you can't form premeditation because he can't reflect. There's no moment that he could have for cool reflection. During the course of this trial, there were a lot of questions that were raised about the investigation of the Chattanooga Police Department, about the collection of evidence, about the time that it took for law enforcement to get involved. This wasn't to distract you or to try to make it look like Jason didn't commit any offense. It was to make you aware that the state's going to ask you to rely on this evidence of this scene. That one, Jason contaminated, but so did every other individual that went in afterwards. They want you to believe that this scene is pristine enough that it sets a story up that Jason acted with premeditation. Cleaning a scene after the fact does not give you premeditation. Removing Jasmine's body, shackling her, putting her in garbage bags, and putting her in the suitcase and discarding her on the riverbanks doesn't give you premeditation. It gives you the use of force. How Jasmine was discarded is not acceptable.
Not acceptable.
Jason should be held accountable for that. Jasmine's death is not acceptable. Jason should be held responsible for that. When you're in the jury room and you are looking through these instructions, it will be important for you to remember it is the state's burden to prove each of those elements beyond a reasonable doubt. First-degree murder requires premeditation, as you saw in that first slide. The state has to prove that beyond a reasonable doubt, and it has not been proven. You will not find first-degree murder. But when you're
These are
evaluating
not the
jury
droids you're looking for.
and the other charges available, ladies and gentlemen of the jury, you will find that Jason Chen did unlawfully kill Jasmine. That he acted in a state of passion and that he committed the offense of voluntary manslaughter.
Okay, so defense just
One of the
admitted
things that the
involuntary manslaughter, which is
state did talk about
it gets rid of a whole list of lesser includeds.
is what's been shown as 226. You guys can recall this red sheet. The state would like to talk about traces in the sheet, possibly not being blood. You have the ability to look at this. We don't know what this is. You won't be able to see anything but this picture in the back, because the state doesn't do anything with the sheet other than collect it. It's not tested. It's not brought here for the trial. So you have a picture. Why we don't have it here, I'm not sure. But it does raise questions as to what this could be. Why is it not preserved? Why is it not entered here? Why is it not tested? This is among many things we don't have answers to. The state also mentioned a few months ago ante-mortem, perimortem, and postmortem. Put a slide up on the screen that showed none detected for postmortem. Dr. Cogswell, in his testimony, said that the time that it takes to inflict those injuries, the 67 wounds to Jasmine, is not the same amount of time it would take for her to die. You can remember that. He said that more than once. The fact that an individual is stabbed 60 times does not mean that she died instantly. You heard about her continuing possibly to bleed out. Jason Chen did not stop stabbing because he thought she was dead and that was good enough. There's no evidence that supports what the state has just said to you. Dr. Cogswell's own testimony refutes what the state just stood here and told you. Dr. Cogswell said that the amount of injuries that were placed on Jasmine, she would have died after the infliction stopped because of the amount of bleeding that she was doing. I know that I've just said this to you, but I'm going to say it once again. This has been a hard case. Jasmine deserves justice. You have given Mr. Chen the benefit of a fair trial. Your attentiveness has been very clear throughout this, and it's much appreciated. In reviewing this evidence, we ask you to return a verdict of voluntary manslaughter. Massachusetts.
They both asked for a guilty verdict. It's a wild case for sure. State gets one more crack at the apple here. Let's see. Please, please, please.
State.
Yes. Yes.
Wow. In opening statement, I told you that we would give you the dots and we would help you connect them. Every single fact we mentioned in opening statement, we proved beyond a reasonable doubt. Every single fact we committed to, we proved to you beyond a reasonable doubt, because that's what opening statements are for. To give you the evidence you're about to see.
She's going to pull up the defense's opening statement.
And then you heard from Mr. Chen's attorney, who committed to a very specific story. Remember, we didn't just talk about that story, right? We backed off that story because, that story doesn't work anymore. And we're going to talk about that story. This entire trial has been muddy the waters. It has been muddy the waters to confuse the jury. The opening statement from the defense was meant to confuse you. It was meant to have you thinking about other things, possible defenses, that the state disproved. Not only did you not hear evidence of what they said in their opening statement, the state outright disproved it. That's why you don't hear it today. That's why we're not going to go back over the defendant's story. And you had asked about transcripts of opening statements. Let's about what we committed to in opening statement as Jason Chen's attorneys. They met on Tinder, wrong? You have text messages. They met on Bumble. Simple thing, but we're just starting with the untruths that the state disproved. They traveled to Chicago together that summer, wrong? End of October. You have text messages that show that he asked her to go to Chicago. You heard that you will see messages where you will see that one of them likes one of them more than the other. Oh, that Jasmine liked him more than he liked her. Wrong. You never saw proof of it. In fact, you have all the messages that they didn't want to show you. They wanted to put them in evidence and then just hope that maybe you'll waste your time reading them. So what did I do? I put them on the screen for you. That weekend before he killed her, he asked her to come over. Oh, she likes him more? No. If you want to waste your time reading the messages, read them. You'll find out that that was not true. What they committed to an opening statement was not true. They drink wine, smoked pot, smoked wax. We didn't hear that just now, did we? Why? Because it's not true. They committed to a story to throw mud at the wall, and it was never true. It was meant to confuse you. And then also, how offensive. The victim drank wine, so he murdered her. The defendant was smoking wax. No proof of it. Zero proof of it. Didn't happen. But let's say that it did. The defendant smoked wax, marijuana, so he murdered her. That is no defense. But it's certainly not a defense when you say it and you never prove it. You committed to this in your opening statement. And by the end of trial, when the jury's no longer confused, you don't want to talk about it anymore. In order to open one of the bottles of wine in the bedroom, Jason had to go to the kitchen and get a kitchen knife to take off that plastic wrapper that goes around the top of the wine bottles. We've seen that knife. Well, we've seen part of it. We'll never know where the other part of it is. We've seen part of it, right? So he was able to get it off the top of the wine bottle. They finish off the bottle. She goes into the kitchen to get another one, and she sees those Tinder messages.
Ding, ding, ding.
The Tinder messages are significant, mostly because that was their adequate provocation. The only adequate provocation you ever heard in this trial was an opening statement, which is not evidence. And then what was the state able to do? Through an expert, who nobody can deny that Mark Hamilton is an expert. He put those Tinder records on the screen and he explained them to you. They are records that cannot be toyed with. They are records that T-Mobile holds regardless of whether you delete things. Those are his Tinder records. And not only did he not have Tinder notifications from that morning, he didn't even have Tinder notifications from November 22nd. That was their adequate provocation. It didn't happen. We know for a fact it didn't happen. So now they stand up here and they say adequate provocation. He was provoked with zero evidence. What the evidence was is that he chased her to the door of that apartment. Ms. Paglino Brewer was the state's best witness and I didn't even call her. I wish I would have. She nailed down our timeline. If you didn't already believe the timeline because she sent her mother her location at 2:18, Courtney knows it. Courtney looked at her phone at 2:11 in the morning after she heard a scream of a woman in, quote, distress. And here's the kicker. They want you to believe this fabricated story that there's no proof of. But how does Courtney help us? Because she attacked Jason. Again, we're uncommitted to this story now, but let's just go back to their opening statement. She attacked him with a wine bottle, and then subsequently, after he kicked her 98-pound body, according to opening statement, he kicked her 98-pound body to the floor where she fell on wine glasses. She then subsequently came at him with a wine glass and he stabbed her irrationally and very fast 60 times. Not true. Why? Because of Courtney and because of that phone location. Courtney was 2:11 a.m. The phone location to her mom was 2:18. 7 minutes. She screamed. Things happened. She was able to know she was in enough danger that she needed to send her mother her location. It wasn't fast. It wasn't fast at all, and we know that. 2:11 is 7 minutes from 2:18. It wasn't fast. She knew she was in danger. She tried to get out of the door, and Courtney told you that she heard a door slam. Jasmine knew she was in trouble. She had time to use her phone before he started killing her. Made up story.
Lizzie Dog, thank you so much.
He kicked her. He kicked 98-pound Jasmine Pace, and then he ran away. But he couldn't get the bathroom door closed because of a bath mat. Couldn't close the door on 98-pound Jasmine Pace. So he had to run in his bathroom. He had to run to his bedroom. Jasmine's right there coming at him with this broken glass. In closing, they don't want to talk about the story that they committed to, because the story they committed to was that he killed her in the bedroom. And he gets, quote, and he gets back into his bedroom and Jasmine's right there coming at him with this broken glass. Jason sees the knife and he reacts and he stabs. Okay, we got two problems there. First of all, his own expert, who I wish I would have called, good expert, says that there's something that happened in the bathroom. There is blood spatter on the wall in the bathroom. Like General Moyle showed you, there is blood in the grout in the bathroom. We know she was moved. Why do we know she was moved? Because Dr. Cogswell testified that on the ground in the bedroom where you see all of the blood, which was almost all of the blood that was in her body, because he was only able to get a small vial of blood because it had all leaked out on the carpet, that for that blood to be on the carpet, she had to be laying on her wound side. That's what he said. Because if she was not on her wound side, the blood would have soaked down to the other side of her body, and the medical examiner would have been able to see that. He said she was wound side down. We know she was moved. We know she was moved, and we know there wasn't enough room right there to just simply flip her over. She was killed. The stabbing began in the bathroom, and then he drug her into the bedroom where he put her on her side with the wound so she could bleed out. We know that. What else is the problem with this? Jason sees the knife and he reacts and he stabs. She's coming after him. He sees the knife and he stabs. The problem is, without question, over and over again, including in writing, our medical examiner says her wounds match her fetal position. It is not true. Trying to confuse you. Trying to throw everything at the wall and hope that it sticks. Really, the worst part of the opening statement is he's scared for what his future entails. But more importantly, the shame that he's going to bring on his family, the shame that comes with everything that he's being accused of today. Manipulative. Selfish. He's scared for what his future entails. He's so scared that he texts on Tinder Victoria at 9:52 with some corny pickup line. He's so scared for his future that he's playing video games with his friends later that day. Don't worry about Jasmine Pace, who's dead in your apartment the entire day until 6 p.m. when you take her to Suck Creek Road. keep in mind, when he tender messages Victoria, Jasmine is dead in his apartment. Uncontested facts. Is this the mindset of someone that just irrationally stabbed a girl 60 times? No. And then he lies over and over and over again. And this is something that General Moyle didn't mention. He lies to Katrina Pace on the phone. He says he hadn't seen her since Saturday. A lie. Then he gets to his parents' house in Nolensville and he's trying to come up with a story. Not the story you heard Monday. But he's trying to come up with a story. It says, the last time I saw her was the 18th of November. The other note, the other sticky note on the desk, says the last time I saw her was the 19th. Trying to get his facts right. He knows he's being looked for. He knows law enforcement's trying to contact him. Why? Because he's got Zach Crawford's number written on a Post-it note. Does he ever say, hey, I killed her because she came at me with a wine bottle? No. He's got Zach Crawford's number written on the Post-it note. He's scared for what his future entails. I'm going to ask y'all to do something for me. It's been a long week. I'm only going to have a couple more requests. When you think about this trial in 10 or 15 years, you tell somebody about the jury that you had to serve on in Hamilton County, you tell them about the case. I don't want you to remember this case as the case of State of Tennessee versus Jason Chen. The trial of Jason Chen. I don't want you to remember it with the suitcase that the girl left on the side of the road. I want you to remember this trial as the trial for Jasmine Pace. Because we talk a whole lot about criminal defendants. You've heard the name Jason Chen a whole lot since we started jury selection last week. Victims matter. Jasmine Pace is not just some girl listed in an autopsy report. She is not the photos that you have seen. Don't minimize her to a name on an indictment. She is a person. She had family that loved her, that you've heard from this week. She was a friend. She was a granddaughter. Please don't minimize this trial to the trial for him. I'm going to ask that you take all this information, all the notes you've made this week, all of the closing argument information. You're instructed to go back there and begin with first-degree premeditated murder. Go back there together and find him guilty. Please. Thank you, Judge.
With that, we'll post the poll. How long will the jury deliberate? Your options are as follows.
Some part of the trial where we'll select our 4 alternates at this point.
One blackout long.
Maybe disappointed.
Less than an hour.
Maybe relieved. But if you are an alternate, you're not off the hook yet.
1 to 4 hours.
You'll be kept
or let us sleep on
jurors it. In case something happens to the 12 that go back. We're not sure how long the deliberations will take, but you will still remain part of an essential part of making sure that this trial continues until the final verdicts are in.
So jurors that deliberate, let's bring out the bingo. Let's bring out the bingo cards. Get the bingo drawing. The first alternate is... It's folded really tiny. Juror number. Family's laughing about something. We're watching something else.
first alternate will be Otis Anderson, juror number 2.
I guess we're going to announce some names here.
You can't talk about the case among yourselves. You'll be kept in a separate room for now. And we'll let you know if you're needed. At this point, you need to go to excuse you. Get your belongings from the jury room. The deputies will take you to another room where you can go.
All right. This is the alternates. They're leaving first to go pick up their eggs and whatever else they left in the jury room. They will be kept in isolation, not being able to talk about this amongst themselves while the jury deliberates.
Yeah, whenever they're out of jury.
I gotta get one back in here.
Let me know when while we're waiting, jurors, you are the final 12 that will be deciding this case at this point. 4 things I'll tell you. If you have any questions when you get back there about the facts, you are the judges of the facts. If you have any questions about the law, they're probably in these jury instructions. So reread the jury instructions if you can find an answer. If you still have a question, just write it down, knock on the door, and get it and talk about it and try to see if we can get an answer for you. And the final thing is that the deputies will show you where the light switch is, turn the light on if and when you reach a verdict.
All right, we're going to give it just a minute longer on the poll. We've got about 631 votes. If you'd like to vote on the how long will the jury deliberate, please get it in now. The verdict light is a light switch they switch to indicate they've reached the verdict.
Consideration of this case with due regard to the seriousness of the questions submitted to you for your determination, and you should strive to free your mind of all acts one way or the other. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality. Look to all the facts and circumstances and the proof before you, and make and report to the court such verdict as you think truth and justice require. You may now retire to the jury room for your deliberation.
And as soon as the door shuts, we're going to start the timer. I will start it. I think I'll be able to get it on the screen here if you give me a minute. we've started our timer.
I will stand in recess until the jury has a question or verdict.
All right, we are officially in verdict watch, and our timer is at 30 seconds right now. So we'll keep that going. We are in jury deliberation. What do you guys think of that closing? Wow, I think there was more volume than needed. I'm going to go ahead and end the poll, by the way. We've got 725 votes. Well, they're still coming in. Sorry. I say we're going to end it, and they're pouring in still. A little more volume than was needed. I don't need to be yelled at to get a point, but I love DA Cody Womp. She did a phenomenal finish. And I think it was important for her to eliminate any doubt or confusion the defense might have introduced. So I think it was good that she addressed it that way. Mr. Moyle did a great job on the initial closing, on the first part, and she really didn't have anything else to cover other than that. So, play the jury song. Do we have a jury song? Library, public. Deliberation one. Let me play a song while I get the timer going. Okay, bud? You all right? Here we go. My son's running around with a GoPro making videos while I'm working. Let's see. Juror's Duty, is that the one?
Happy birthday. You look good.
Thank you.
We're sitting in the jury room full of 12, listening to the stories as the facts they delve, taking down the notes with our pens and pads, every word and gesture making it last.
Questions on our minds, we write them real clear. For the end of each testimony we'll offer to hear. A duty on our shoulders, weighing like gold, ensuring that the truth shall be told. We're the jurors with eyes open wide, seeking justice with no place to hide. Thoughts and doubts we carry with care, returning the verdict we do declare.
When hours grow heavy and our minds lose steam, we ask for breaks to keep our thoughts clean. Clear heads and clear hearts we must maintain, focused on fairness through the strain. In the huddle we discuss all sides, the facts and the whispers, no place to hide. We ponder and reason, debate with respect, to make sure our verdict is truly correct.
Chaz decided. I closed out the poll.
Voices sing a decision so pure. In the court of law we'll stand and ensure judgment to offer with balanced faces, the duty of jurors in all the right places. We're the jurors with eyes open wide, with no place to hide. Thoughts and doubts we carry with care, returning the verdict we do declare.
There we go. That was the wrong song. I clicked the wrong one, but that's it here. All right. Let's see. Oh, it just wants to just play all the songs, doesn't it? All right. All right. Chat has decided. I pulled up the. I closed the poll as far as the verdict goes. It looks like 1 to 4 hours is the winner with 70%. Less than 1 hour at 13%. Let us sleep on it 8%, and the shortest one, which is about one blackout long, only 6%. It shows that one. So, all right, the jury's going to get it right. I think they will. This has been a jury that throughout the duration of this trial has been attentive, has been taking notes, has been asking great questions. We've not heard them asking for a lot of breaks. They've not been demanding. I think they took this very seriously from the get-go. They are sequestered. They wanted to work the weekend. I mean, they could have been like, "Oh, I'm sequestered, right? Free hotel, whatever." They could have enjoyed it that way. They did not. They were very serious about what they're doing, and I think I don't know who other than Mr. Otis, who is not deliberating, but I think it's going to be Angela says, "I missed the whole trial. Should I go back and watch it?" There are some days you should definitely watch. One of those days was Saturday morning. So the 100th of a second, we've got the Olympic timer going. So we'll see what happens here. And it's a dancing emote. I don't know how to do moving emojis very well. I'm supposed to be able to do them, but every time I've tried, I've messed it up. I think they want to be done with this. I agree, but I think I don't think they're going to rush it at this point. They've been so good and so dutiful up to right now. I don't think they're going to be like, screw it. It's taken too long. They were planning on 10 days, and they're not there, right? We're on day what? Day 7 by my count.
Thank you, sir. You're my new best friend.
You're welcome. I wish I had gone to the courthouse today, says Carrie. It's not too late. You might be able to be there for the verdict. You should also watch the end of Saturday's stream if you weren't here to just say, yeah, we've had some good videos to sort of break the ice from Josh, both this morning as well as Saturday afternoon, or is that Monday afternoon? Today's Monday, right? What day is it? Today's Monday. Larly Annie, thank you very much. You've been very generous with super chats and gifted memberships, and now comes in with 5 gifted memberships. Carrie C. in Tennessee, you just got gifted a membership. Congratulations. Betsy, Kelly, Sherry Miller, Denise Cullerin, wonderful people. Thank you very much for your generosity, Laurie Lee. All right, playing catch up. How much faster would trials be if they just let chat choose the verdict? We're fast. Yeah, I'm not sure if I'm good with that. But still. Purple Coconut, still disappointed they didn't mention little guy in the corner. It's all right. Dateline, they've got a story to sell. And they did a fairly good job telling the important parts of the story. I don't think I was an important part of that story. It was just a little segue. So I really don't understand the heat of passion part. Is there another case that had this I can compare to? Ozzy, heat of passion. If this is the example I go to. If a couple who's been married a long time, one of them is at work and comes home to find the other engaged with activities with somebody who they were not aware was in the relationship, it might, in that moment, cause a rational person to do something irrational. And in the heat of passion, somebody might get hurt. That's a heat of passion type moment. The defense tried to spell this out and lay the story out that Jasmine had gone out to the kitchen and seen the Tinder ding, ding, ding notifications on the phone, and thus in the heat of passion, as she was like, what? There are other women who are on the same app, which that they had admittedly said that's where they met. They're like, what? You're on Tinder? The defense literally said that's where they met. So that caused her to be so upset that she came at him, but it just didn't add up. Oh, wow. Andrew C. gifted a membership. Thank you very much, Andrew C. That's a lot. That's very generous. Iris also. Apparently there's a little gifting train going. Thank you. Thank you. Congratulations to all the winners. Angela, you were the latest one. Angela Javornik. Did I get that right? Angela D. Georgievic. I think that's what it is. I think so. We decided. Didn't they meet on Bumble? They did. Defense said they met on Tinder. Do we know if Christine's there today? We didn't see. We didn't have anyone in the courtroom, so I do not know. I think it's probably a safe bet to say that she was. Did they end up recovering her body? Yes, they did. Her body was located using the ping locations from Jason Chen's cell phone. It was located next to the Tennessee River, right by where the phone pinged, in a suitcase on the bank down the hill. It took them less than a minute after they arrived on scene to find it. Virginia, you are back in green. Welcome. Hello, my friends. I hear there's a verdict watch. I'm here to hear the verdict music. We will keep our ear to the ground on that and see if that happens. I've got it queued up in case it needs to be played. Verdict today. If I had known this was going on, I would have gone every day for you. Twitter pated. Thank you. I appreciate that. We will have more court cases. Obviously, there's stuff happening all over. We're looking at a couple of the big cases. Obviously, Corey Richens in Utah, which I think is, is it April 28th? 4 weeks long. I think that's Corey Richens. Brian Koberger is the end of July, I think July 28th through or the next 12 weeks. No, not July 28th. I think it's August 11th through the next 12 weeks. But those are big ones. When the Kentucky sheriff case gets a schedule, if somebody knows that, please let me know. That's one we would love to have a court watcher on in that trial as well. AMC gifted 5 memberships. Thank you, AMC. Thank you. Corey Richens, Karen Reed, and Florida case all in the spring. Karen Reed, I probably would not want to try to get people to go to, just for the fact that the happenings outside of court are pretty heated on both sides. I want to watch the court without that little circus or drama that's going on. I'm not saying that either side is wrong. I'd rather be able to focus on the trial and the evidence that's admitted to court and the testimony that's provided. Lori Daybell is going to be wild. Kentucky Sheriff has a bail hearing coming up. Wayne, let me know what the date is on that. Pike County Massacre in Ohio. That's the trial for the dad on that one is what's left, Lisa, which will be interesting because the mom and the son got sentenced before they did their part, which was part of their plea deal when testifying against him. So hopefully they're still willing to do that. But I'll tell you from experience, that court was very difficult to watch. So, hey, bud. Which cord? My son's like, can I have a cord? What cord do you need? Which one?
To the camera.
The cord to the camera?
Mm-hmm.
You just want this one?
But that's the wrong kind.
What?
That's the wrong kind.
What kind do you need?
The one with that tip that you were holding first, that should be it.
I'm looking, bud. I had one here a minute ago. About this one right over here. Nope, that's the same as this one. These are the same. I'm pretty sure I had the cord you need, but I don't know where I put it. How about this one? Did it work? All right. Have fun. Let's see. Other cases coming up. Blackout incoming when something gets unplugged. No, he's very good not to unplug anything. I did just have 3 spare cords sitting on my desk that I didn't know I had. You're going to have him sign the cord out back. No, I'm just going to order a replacement. I'm just going to assume that it's a problem. Danny's going to be at the Corey trial. I need to figure out what we want to do there. I've been thinking about that, talking about it with my wife. I really, really want to cover that one live. And it might require me to be there. And if I'm live and there, I cannot go live from inside the courthouse. So, might have to get somebody else that can go to a 4-week trial. And that is, it would require somebody local. So, thinking what I could do there. Angela, did you just barely send it? I'll have to look. No, that was my youngest. My middle one is the sometimes up for adoption one, who it really isn't. But the youngest one is, I gave, well, my 2 youngest ones came in and found a bunch of my old GoPro cameras, and they found 3 or so of them. I have 4 or 5 that I've had over the years from different filming gigs, and we were able to piece together parts and batteries and cables and memory cards. So they're both running around making videos right now. All right. Only one girl. 6 kids, only one girl. They're not intended to be disposables. Greeners, I've used them. I literally attached a GoPro camera with a what they call a pipe clamp mount to the lance of a knight that was in a jousting competition. And it took a direct hit from the other knight. Got some great video, but the GoPros aren't made to take that sort of abuse. So I have a couple. Several of them are broken. Let's see. I sent it 2 weeks or so ago. I can send it again. All right. I'll take a look at it. Ann says, I'm finally back. Welcome back. Good to have you here. All right. As far as the deliberation goes, the jury has to go pick a foreman, which they've probably done by now. They were about 15 minutes in. I think they probably have a good idea because the judge has been asking them questions, and I mean there have been some communications back and forth from the jury to the judge unsolicited and from the judge to the jury unsolicited. And so I think they probably already have somebody who's that designated, I'll write the letter, I'll be the spokesman. Otis was going to be the foreman. Now it's all a mess. Could be. I think it was a lady, though. Can the jury still ask questions? They can. Donna, what we heard right before the jury was dismissed was the judge sort of, pouring a little water on the, ask me anything you need to know thing. Saying, look, if it's a question of the facts, that's for you to decide. All right? If it's a question of the law, I've given you all the instructions. So there, with that basis, if for some reason there's something else you have to find out about that's not covered in the instructions and the law and the facts that you have before you, you can write a question. We'll see if we can help. But it really, I'm not expecting a lot of questions from this jury. Goose Toots, I always listen to RA while delivering mail. That is awesome. Did they find the owner of the drone that got the fire plane down in LA? I don't know yet, but I've heard it was a member of media. I'm not sure if it was like professional media, because most like the news channels, they don't launch drones. They occasionally they will, but there's a lot of work, and it's more work than a lot of the news media members are willing to put in. They also have helicopters, so why not do that? Did you stream Saturdays? Yes, we did, Sam. I do have a text alert system that will tell me when there is a verdict, but it's called X. Let's see. Let me just look. There's not a lot of tweets on this one. So we'll see. We'll see if something comes in on that. But otherwise, we've got a live stream with audio that will interrupt us at any moment if something happens. Oh, a text alert I could send to all of you? Huh. Sort of like a spam call, but in text format. Can you imagine me having my own spam service? I did that one time, and this is, I won't get into the details, but many years ago, I supported a candidate for sheriff. A friend of mine, I'd done a lot of filming for them and work for them and gone through Citizens Police Academy at that sheriff's office and everything. And I supported the candidate for sheriff, and I made a recording for a robocall, a political robocall. And they said, okay, what we can do, the campaign manager was talking to me, and he's like, what we're going to do is we're going to spoof this number so that it'll come and it'll look like it's coming from our headquarters, and it's just a machine. If anyone calls back, it'll go to the machine. And I said, no, I refuse to call people unless my number shows up. I said, I want you to put my cell phone number on there, because if I'm going to stand up and own this message and tell people that this is who I'm voting for and why, I'm going to make it personal. And I'm willing to take the heat. And if they have questions, I want to be available. And I thought that was the right thing to do. Turns out nobody wanted to call and discuss the actual call. But a whole ton of people said, hey, I just missed a call from this number. So I got a whole bunch of people saying, hey, I was too late to answer. Who is this? It was pretty funny. Anyway, robocalls, robotexts. I would need everyone's number to do that. Or we could do an app. I see you talking about EDB's app. A good app costs about $15,000 to build. I've priced that out. Of course, I've got a son who's learning how to program, so maybe I just need to promise to include him in the will, and maybe that will be enough. Just make a mediocre app. That's all we need. It just has to be functional. One of my many business ideas, a long time ago. I mean, I started with the idea of buying and flipping houses. We bought the first house and decided we were going to live in it, and we did for 10 years or so. But one of my ideas was to have an app. I think Angela's calling. Hang on just one second.
Call from?
This call costs about $15,000.
It's Mathis, 15,000. How are you doing?
I'm doing okay. I had to call in sick for work today, but I felt much better by the afternoon, and I had a very nice day with the cats. Loved listening to you talk about your own cat having multiple families. Yes. I'm just doing with the multiple cats. And I wanted to call you about an exciting opportunity, because there's two things you can do in one go.
What's that?
You're talking about a good app. Mm-hmm. So there's this thing where you can use apps that already exist. And
are you being sarcastic?
And if you're talking about an app that can notify a lot of people, that's what Discord is for.
I'm terrible at that. That's the problem. I feel if I officially have something attached to the channel that needs maintenance and work, I'd feel like I'd have to do it. I'd feel bad about having something that just got neglected. And I'm terrible at posting in Discord. I love As the Gavel Drops. They do a great job.
Mm-hmm. But you can probably get help there if you're just thinking about something like a feature where people can select a role, like Recovery Addict watcher. This court has the possibility to ping everyone that has given themselves a certain role. And so you could write at Recovery Addict watchers. You'd have to try to not make it at Recovery Addict. You can make it ping everyone in a row, and then you just write something like verdict is in, and then everyone who has that role on Discord would get the notification.
I understand that. Knowing the demographics of the channel, though, I know that a lot of people struggle with, and just Discord just isn't their thing. But that's not how
I understand that. I just wanted to explain that the feature already exists in very convenient apps.
Maybe if I find the right app where you guys can all join a group and I can just ping the group. That wouldn't require a lot of effort on my part or a lot of training on your part. I'll keep my ear to the ground and see if I can find something.
I mean, you can always do it like a WhatsApp group or Signal or something.
I need to figure out how to tie my phone to WhatsApp without giving away my personal cell phone number, because that's the challenge I have right now. My WhatsApp is busy doing something else.
Yeah.
Well, good ideas. Good ideas, Mathis. I appreciate that.
Yeah. And by the way, February 12th, I hope that's in your calendar.
Is this the Maya trial?
No, that's Maya appeal.
The Maya appeal.
That's the oral arguments and the Maya appeal, where all the briefs have been filed, and Nick Whitney's new firm has been substituted for the Andersons.
There's a lot going on there, and that's really cool. My only concern is my live view is going to be at another trial during that time down in Florida. So I probably.
Oh, what trial?
I don't remember, but we could ask to Trial TV Live because they're going to be running it.
Okay.
I know it's it's either a pretty gruesome one or it has some elements that we're probably not going to cover directly on the channel, so it'll just be posted to Top Mark Media channel and their channel.
So, yeah, you wouldn't need Trial TV for that because so it's in the Second Circuit Court of Appeals, the District Court of Appeals, and they have a YouTube channel where they live stream. I caught lawyers that I knew on there. Now I'm
in
being eaten by a cat.
Second District Court of Appeals, do they allow their stuff to be reused? Because I've already got one cease and desist letter from the appellate court.
I don't know, but it's a YouTube channel, so I would expect that they don't claim like copyright on like their public proceedings. I know that the various other courts that do also broadcast their oral arguments, like, for example, SCOTUS, I would highly suspect that they can't like copyright their like an audio stream of oral arguments.
Cool. Well, I'll give it some
you
thought.
You can email someone at the second DCA.
Well, I've got the calendar pulled up.
It
looks, I'm seeing it there. Johns Hopkins Children's Hospital versus Jack Kowalski, Maya, and the estate of Beata. Yeah. Is Nick's firm is Gunster, Yoakley, and Stewart?
No, that was the original appellate firm.
Okay.
That's the one where it's very cool because their original appellate counsel is like Michael Tanner and Kenneth Bell, who are. Michael Tanner was the previous president of the Florida Bar, and Kenneth Bell was on the Florida Supreme Court, state Supreme Court. And then they had to get Elliott, Ferrier, and I think there's another partner in that name, could be something like Harris, for the trial before Judge Carroll, because the Gunster firm had bought a firm where Judge Carroll's brother-in-law worked. So they had to, for the trial, for the trial portion, they had to get stand-in appellate counsel. So that's why Mr. Elliott and Ms. Ferrier were.
Well, we'll give it some thought. We'll look at the calendar and see if it fits, and see if we can do the oral arguments. That would be cool to hear.
Yeah, there's a time in there. I don't should be on the docket. It's like Florida time zone, which would be yours too, I think.
I'm just showing that it's in the 9:30 session, and it's the third one on the list, or the fourth one on the list. So could be any time, or it's 30 minutes per side. So 9:30, 10:30, 11:30.
Yeah, the others are typically 20 minutes per side. Yeah. And they stream in like 2 or 3 hour blocks, in my experience.
Okay. Sounds good. Mathis, thank you very much. I appreciate the reminder, and I'll see if I can save you another $15,000 and wrap up the call here a little bit for you. I appreciate the call.
And Nick Whitney's new firm's called Childers Law. The other lawyer's last name is Childers.
Okay, Childers Law LLC. I see him there. Sounds good.
Yeah, it's definitely. I'm 90% sure that it's going to be the same person doing all arguments as before. Probably. I would.
He was a little dry.
It would be really cool. It would be really cool because last time it was Michael Tanner, and that for the Kowalskis, and that it's pretty cool knowing that the guy was president of the state bar before.
Yeah, he's got some weight behind his name.
Very high
he's
caliber.
A respectable name. So, Mathis, thank you very much. As always, it's good talking to you, my friend.
Yeah, have a great day, everyone.
You too. See you.
Bye.
Thank you, Mathis, for that. Hilda B., Bug Dugger, both gifted memberships. Thank you very much. As we reach the 30-minute mark, now 32 minutes into jury deliberation, we are standing by to hear if anything happens in the court as far as a verdict goes. So we'll give them some time. Not to be picky, can we remove the milliseconds from the timer? I will when it switches to hours.
Call from Angela.
Now it's Angela on the phone. I mixed you up with Mathis. I should memorize your number.
Yeah, we really need to send you a list of all the land codes, so you know.
46, 49, they're so similar. How are you doing?
Yeah.
We haven't talked in a long time.
I'm doing good. Sorry for being absent. I just had a lot of going on, and I just needed a break. So that's why I was absent. So first things first, the mail I sent you was about, I found Dr. Russell, the paper she wrote. So that was what I sent you. And another article that is relevant to the case that you might find interesting.
Okay.
But the only reason why I called you, not I really need to do something, and that's to go back to a year, 365 days or plus, and find every single clip you tried to pronounce my last name and put it together.
Don't do that. Don't do that. It's terrible. I've never got it right.
Well, you came close quite a few times.
Let's see. Post something in chat so I can say it one more time.
I'm not in. Hold on.
Okay.
I'm on my phone.
Okay. Let me find something by you here. I scrolled off the screen.
So I just sent it.
Okay, there we go. Georgievic.
Yeah, there you go.
First try. I got it.
Yeah.
So delete all those ones where I said it wrong.
Only K is pronounced as C, but K is also works. That's also okay. Georgievic.
Georgievic.
Yeah, that works too. That's also good.
What did I say differently? It sounded the same.
Yeah. We the Balkan people, ex-Yugoslavia people, we all have the same ending of the last name. So yeah, good luck pronouncing about 20 million people's last name.
Yeah, I'm terrible at it. You know that. That's awesome.
Yeah. So I should go back and watch Saturday's live, right? Sorry for missing the whole trial.
It was one of the best days. We had surprise witnesses who didn't know they were being called until they heard their name in court. That they weren't subpoenaed. That was the dad. The testimony was good. It was a little spicy. There were some good arguments back and forth. And we had a lot of arguments. The longest argument I have ever seen about whether or not a witness should be allowed in as an expert happened that day. It got a little slower after that in the afternoon, but I think that was some pretty good court that day.
Yeah. Okay. I'll go back and watch. I hope that based on the comments, it seems like he's guilty. So I vote for guilty, even though I haven't watched the trial.
Well, not just the comments. In the opening, his defense lawyer said he's guilty. And in the closing, his defense lawyer said he's guilty. And in the closing, they said, we want you to find him guilty. On defense, we want you to find him guilty, but just of the involuntary manslaughter, the step down. So it's going to be either first degree or involuntary manslaughter because they've literally admitted to it. It can't be anything lower than that. Or the jury's messed up.
Good luck. Well, thank you so much, and I'll let anyone else who wants to call in. Otherwise, see you in chat.
Awesome. Angela, thank you very much. Glad to hear you're doing well.
Thank you.
We'll see you.
Bye. Thank you. Bye-bye.
All right. Let's send tons of last names to be pronounced just for your watching. Purple Coconut, I got yours. It's perfect. I know that one. I'm ignoring the ones that I can't pronounce. I just skip those. Or I just use the first name. Let's see. Jury deliberation time, 37 minutes. We still are waiting for... Oops. Can't have my timer on the screen at the same time. Yeah, I can. I just have to change this to be camera 2. Like that. There we go. Okay, I can switch back and forth. That works.
I was kicked back, taking it easy.
All right. They didn't say how late they could go, did they? No. And Mel, this judge seems to be inclined to let the jury do as much as they want. Iris, I can do your first name, but you don't have to give out your last name. That's all right. I was becoming dizzy. I know at an hour, because this is an app that centers the time, at an hour it adds time and it moves things over, so I'll have to adjust it then as well so the seconds show up again. But let's see who else wants to speak.
Hey, this is Alice.
Alice, this is RA. How are you doing?
I'm good. How are you doing?
I'm doing great. Is this the Alice?
The Alice in Chattanooga?
Yes.
Yeah. That's me.
Awesome.
I just wanted to thank you for covering. I know that our courtroom is a hot mess. I know that our courts are a hot mess, and you've been very patient with us as we hot mess along.
We've seen a lot worse, and I like as I'm sort of I've been involved in this sort of production, trying to put something live. It's terrible, and so many things can go wrong. I like to give them a little bit of slack, and at the same time, elbow them in the ribs a little bit. So this one is not the worst we've seen, and it was really good. So.
That's good anyway, but I appreciate you streaming the whole thing. It's been really good to see everybody's outside opinion, because all I had was our opinion, and we're like, well, it's just Brian. But, it's good to see other opinions.
So I have to ask you, you know Investigator Mark Hamilton, right?
I do.
Were you able to send the email and put a little bug in his ear?
All of his information is in my office.
Okay.
And since I was out for MLK Day, it will be tomorrow before I'm able to get in touch with him.
Okay. Sounds great. I would love, I really would. I'd love to have an interview where we don't necessarily talk about this case as much as we talk about his experience and job. Just his job experience has spanned the entire length of time that technical forensics has been a thing. And so, from the very beginning where cell phone evidence started being introduced in court, he's there for it. And it's developed all the way, so it's awesome. And I may or may not, if we're able to pull off an interview, I may or may not have the exact same shirt on order from Carhartt that he wore
Well, he
during
will-
the first.
He will talk your ear off. I know I've gone down there when I used to work over him when he worked at the police department. I'd go down to take in mail and be like 45 minutes later, and I was like, Mark, I really got to go. But he showed me a lot of stuff on how to do things like that, and I was like, I really wish I had the opportunity to do this. But,
It's cool.
You know.
I don't know where he's at in his career and how long Chattanooga gets to use his expertise, but he's a major asset. Having somebody with that much information and experience is wonderful. So I'd love to be able to talk to him
Yeah.
if that's a thing.
I'll see what I can do
All right.
about him.
I appreciate it, and thanks
And
for the
I'll let
kind
you know.
words. Appreciate it.
Oh, thanks for doing all you do.
Thank you, Alice. We'll see you.
Bye-bye.
Bye. All right. RA's love for checkered Carhartt expert is so wholesome. He's amazing. I'll just put it out there. Just wear a suit. He probably would. No. Can we briefly talk about the fancy flashy light on your keyboard? This one here? Yes. This came with my desk, and it didn't work properly, so I called them, and over 2 weeks and 18 emails were able to send a replacement, but the replacement was literally everything you see here. This top desk, like 70-pound box with a replacement light strip, and they said, just take it out of that. So I now have an extra top of a desk with no legs, but working lights. And I can program them to do a million different lights, and it's like they build up purple right now. It's got a little remote control. They can make like rainbow colors, like whatever. I can speed them up and slow them down, and here we go. Is that dizzying enough for you? But I love it. I bought this desk for that very reason. All right. Fun little pizzazz for the desk. Eventually, I might get the lights to be to the point where they will, that's too much for me. That's distracting. Where you guys will be able to enter commands and they will change, like to get my attention, the lights might flash a strobe or something. We're thinking about that. Like it's not going to be like Ryan Hall, y'all, Red, there's a new notice from the weather center, but something similar. All right, next question. He's racing by my house. Code Reds would be so fun. I see you've got an extra R in there. You'll have to decide what light pattern to play during verdict music. DJ RA in the house. We'll see. We'll see what happens. Super chats can make it glow. I could time in literally the program we use to put these to put the commands, like take a seat and everything else. These responses. This program is designed specifically for interfacing with lights. It's just these particular lights are cheap because I'm cheap. So I haven't seen the need to get really expensive lights that tie into my computer. I still miss the robot voice reading super chats. Red Pen, I took the advice of a lawyer who I respect, and that was Emily D. Baker, when she said, that's dangerous. That's dangerous for your channel. And I shut it off for that reason. What is your opinion on the broken chain cuffs? Did she break it, or did he when moving her? John, I thought that the state describing, the prosecutor describing how those cuffs could have been broken because she has more force to be able to move her elbow than her other wrist. If the first cuff that he put on her was the shackle and she broke it, and then he put on the handcuffs, that makes more sense to me. It doesn't make sense to me that she was handcuffed right hand to right ankle and then the shackles and was able to break the ankle, break the shackle. I think that only one was on and it broke, or it was him trying to drag her body and it broke, just because they're cheap. I don't think she would be able to successfully break the cuff or the shackle chain while her hand was handcuffed without leaving some sort of mark on her wrist, which there wasn't. All right. Is it Lumia Stream? Yes. Lumia Stream. I love it. I've used it almost since the get-go when we started. It was cool when Mark was cited in closing. He's really good. Just getting back, what was the poll stats? Most of us think it's going to be between 1 to 4 hours, probably because the jury is very deliberate and very detailed. Movement in the court. I'm seeing some people move around, but I've got the audio turned on. If anything happens, you'll hear it, and we'll jump to it immediately. So it's just somebody walking back and forth in front of the camera. Could be a bailiff, could be somebody coming in or coming out. But I'll let you know. What do you think was his motive? Is he just a true psychopath? Tequila. I could think up a lot of scenarios that that fit, that it could be, that would even possibly make sense or sound legit, but it would just be speculation. Without any evidence about what happened, we don't know. We're basically looking at the pieces that are left behind and trying to build a story, and without him actually telling us, or some other video or audio recording that makes more sense. I don't know why. At 2:11 she would try to run for the door, when she clearly was there willingly and had been in the past. They'd had a relationship that went on for several weeks. They'd traveled to Chicago together. I don't know why suddenly something went wrong and she wanted out. But I can see scenarios that make sense in my head that didn't involve.
Has a verdict. Whoa! Defense counsel gets here. Talk about next steps.
47 minutes. Seven days of testimony lead up to this moment where the jury goes and deliberates for less than 1 hour before returning a verdict in this first-degree murder trial of Jason Chen. He's charged with killing Jasmine Pace. The judge talking now about people who may testify in the sentencing or prior to sentencing. That is remarkable. I am stunned. Less than 1 hour. If you give them 15 minutes just to decompress and say, wow, we can finally talk about it. Let's choose a foreman. Half an hour just to fill out the paperwork. They walked in there and all of them agreed. All of them agreed. The evidence in this case was overwhelming against the defendant. His own lawyers admitted his guilt both in opening and closing, and the jury, by their verdict, agrees. All right, the judge is just getting some paperwork ready. The jury is not present in the courtroom yet. It will be some time. They're literally discussing whether or not people are going to, informally, off the record, discussing if people are going to testify prior to sentencing. It may be some time yet before we actually hear the verdict, as everyone has to be gathered, family has to be notified. I'll turn off the music when it's done. I've waited all week for this, Regina. There we go. Music's done. We are waiting. We are waiting for the verdict. We just got the notice. That was the first notice we got, that the jury has a verdict. Oftentimes that notice comes out via text message instead of the judge announcing it, but we may have a significant amount of time before the actual verdict gets read. Wow. Wow, wow. That was quick. That was quick. Judge is present. Audio is on. Yeah, I have the rare ability of being able to hear something while I'm talking and know what's going on. If there was anything that was pertinent, I would have cut it immediately. But they're literally talking. They literally were talking about his parents testifying and maybe some other people testifying prior to sentencing. And that's all. The verdict is in. We have a verdict. 47 minutes. Just over 45 minutes of deliberation. Where can we download the verdict music? It's available for free on YouTube if you're a creator, in the creator library. I think it's called Right Here, Right Now, or something like that. But it also is known by another name on YouTube as... I don't recall off the top of my head. If his parents do testify prior to sentencing, which they may do, it's going to be through a translator. His mom does not speak English natively. She has been present, and I believe they have had a translator for her in court. We'll see if they still do impact statements prior to the sentence, even if it's a fixed sentence. I have the not so rare ability to exclude even things I'm listening to. Wow, that was quick. That fastest verdict of the year so far. Of course, it's also the first, I think. Well, no, we've had one more. Does the jury do the sentencing? I believe, Carla, the way I understand it is if the jury votes that he is guilty as charged, that there is a minimum mandatory of life without parole. So in that way, yes, the jury selects the sentence because there's only one option. But the judge actually would pick the sentence, is my understanding, if there was anything else. Regina, you're all good. You're all good. No worries. I know everyone wants to hear everything. I made an executive decision to play it because the judge announced the verdict. Normally we see it through Twitter, and I do like playing the music. A lot of people wait for the music. A lot of people listen for the music, have it on the other room, and that's their notification that there's a verdict. So thank you, Regina. I appreciate you. All right, we have updated the title to show we do have a verdict. We are 13 more likes away from 1,000. If you're able to click the like button, we'd love it. There it is. Thank you, say my name. The verdict music is also known by Emotion by MC Andelco on Spotify.
In front of the Walmart. Thank you, sir. You're my new best friend.
Tony's like, first full trial, done. You did it.
Are we going to address subject matter jurisdiction?
All right, we're just We don't know exactly the timing. The judge did not announce when the verdict would be read. We also don't know who's going to read the verdict. If it's the jury that reads the verdict, it might be very difficult to hear. The jury has been difficult to hear a lot of times when the judge asks them questions. So
I think I'm about to catch a whooping.
if the judge reads the verdict, it might also be difficult to hear. He's got a quiet reading voice, and his microphone doesn't seem to capture it very well. Wow. Thank you. Oh, the odometer, yes, the like meter exploded. We blew past 1,000. Thank you very much. We did a verdict poll. It was very heavily on the guilty side. I wouldn't say unanimous, but very heavily. I think over 80%, if I remember right, on guilty, with almost the entire balance on a lesser included. Which is only appropriate because his lawyer literally admitted guilt, said find him guilty of the lesser, and the next lesser included down. There were options, right? Because within the first degree murder charge is the lessers of second degree murder, voluntary manslaughter, aggravated assault, reckless homicide, reckless aggravated assault, criminally negligent homicide, assault, and reckless endangerment. So there's another 8 options they could have found for. And they said, go for the next one down, which all it does is get rid of the life without parole. That's the entire purpose of this trial, was to maybe give him a chance at getting out at some point. There have been times I've thought of withholding my like until a time like this when it is really needed. I always resist that temptation because the like in the counter is better than 2 likes withheld. A bird in the bush is better than a bird in the hand is better than 2 in the bush. Is that what it is? We'll see what happens on sentencing here. The judge using his standing desk. That's why we're seeing his head when we're looking at the logo. He has a standing desk that he periodically switches between. Susan, thanks for clicking the subscribe button. We call that admitting to be an addict. Thank you very much. This actually is perfect timing for me because I've got an interview tomorrow about this time, little collaboration interview that I'm really excited about. I'm not going to spill the beans, just like with the lawyer you know. I didn't want to spill the beans. He did before I did. So we'll let you know when it comes out. But Larly Annie 1, Blackout Long for the win. She says, thank you very much. This was short. It was really short. If he has a chance of parole, I doubt he will get it. If he has anger issues, he won't last long in prison. I don't know. I don't know him. All I know of him is what I've heard. And there have been, there are plenty of stories out there that are not evidence the jury isn't considering about, roommates that thought he was strange, or his behavior at this point or that point that is a little different and made people a little nervous. But I don't have any indicator of what he's like as a person other than this one act. I think that's the fastest verdict I remember. 47 minutes. On a 7-day trial, it is fast. It's very fast. And maybe, people might say, if you hadn't sequestered the jury, maybe they would have taken their time and done a more thorough job looking at the evidence. Maybe they might have, but I don't think we would have had a different result. I don't think that hearing what the jury heard in evidence in this trial, I don't think they would have come to a different result in this case. There was no court on Sunday. There was court on Saturday, and it was really good. If you missed it, I would recommend going back and watching it, especially Saturday morning. Sarah Boone was twice as long. Lady Draconis, welcome. Good to have you here. Lady Draconis is one of the fabulous mods over for Rob at Law and Lumber, and a good friend of the channel. A phenomenal gentleman, and I'd say mentor in the YouTube world. And I am lucky enough to say that I have one of his handmade pens that he made personally for me. I love it. I carry it around in my suit pocket and use it regularly because that was the requirement when he sent it. He's like, you can't just leave this on the stand. You have to use it. So I do. I think it's about ready for a new ink cartridge. But wow. Maybe they accidentally hit the verdict reach light. The bailiff gave them specific instructions on where the light switch was to indicate that they had reached a verdict. Wait, I do have a suit. I was doing security during the Olympics in 2002, and the security position they wanted me to work was one of a more undercover position, where I was definitely security. I mean, I had the radio and the ear fungus, but they wanted me to blend into a more formal setting. And so I had to get a suit for that. Okay, here we go. It looks like Mr. Chen's coming in.
Told the jury has a verdict, state prepared to receive the verdict.
Yes, Your Honor.
Defense ready to receive the verdict.
Yes, sir.
Bringing the jury whenever they're ready.
Here we go. This is it. They're coming in right now. 47 minutes of deliberation. They reach a verdict. That's about the time it takes to figure out where the verdict forms are to check the box. That's it. That tells me that no jurors had to be swayed, had to be talked into or talked through their vote or make a decision at the moment. They had all reached that conclusion already based on the evidence. We got a red coat. I want the yellow. My sister got a yellow. I wish I had that one.
All right, please be seated. Let's see, your name is juror 15, is that correct? Yes, sir. All right, are you the foreperson of this jury?
Yes, sir.
Have you arrived at a verdict?
Yes, we have.
And it to reserve.
So juror number 15 was the foreman. Two-page verdict, 2 charges.
Juror 15, if you could stand and read the verdict. Chen, stand with your terms. Start with respect to.
With respect to count 1 of presentment 315-228, we, the jury, find the defendant, Jason Chen, guilty of first-degree premeditated murder.
This is an emotional verdict. Everyone needs to maintain decorum, please. All right, rest of the jurors, if this is your individual verdict, please so indicate by raising your right hand. The record should reflect that everyone's right hands are raised. All right, sir, read count 2.
With respect to count 2 of presentment 315-228, we, the jury, find the defendant, Jason Chen, guilty of abuse of the corpse.
All right,
guilty as charged.
If this is your individual verdict, please so indicate by raising your right hand. The record should reflect all right hands are raised. All right, maybe seated, sir. Maybe seated, Mr. Chen. We decide according for the polling of the jury.
Oh, Your Honor.
They do not poll the jury.
Chen, as 13th juror sitting in this case, I do agree with the jury's verdict of guilty and hereby pronounce you guilty of the first-degree murder of Jasmine Pace. This brings us to the sentencing phase of this particular matter. The jury will be asked to determine whether or not there's the presence of an aggravating factor. This will require proof. We're going to do that tomorrow. So at this point, to let the defense and the state put together any proof. If they want to put some on, then that'll be happening tomorrow morning. Again, you can't talk about your verdict with anyone. You're still part of this case, so you must refrain from being exposed to any media, and also must not talk about any sentencing matters or anything about this case with each other until you're back in the jury room. Okay?
I was completely
That will
wrong.
release you,
I apologize.
Again, reminding the court's admonition to not discuss anything about this case among yourselves until tomorrow. All right, that may be
matters dismissed till tomorrow. They're going to be asked if there are aggravating factors in this case. That's their decision. They're still sequestered.
Please be seated. West will resume tomorrow at 9 a.m. There's a regular docket. Might be better for parties to be ready to proceed at 9, but how big's the docket tomorrow? That's it? All right, this is trial for 9:30. Unless you need more time tomorrow morning, we can start later in the morning if you wish. Mr. Weiss, if you need any witnesses you need to get together, same with the state. Do you prefer 9:30 or 10? Yes, sir, 10 o'clock. Okay. Court will be in recess till 9 a.m. tomorrow. This court will be in recess till 10 a.m.
Mr. Chen glances back at his family just briefly as he's let out of court. He's now has been found guilty.
You don't have to talk to anybody about your experience if you don't want to. The lawyers understand that. They'll respect that. You'd just rather not talk to anyone. You don't have to. The lawyers do appreciate, and I certainly did when I was down there, getting feedback about what they did right, what they could do better. So if you are okay with it, they may ask you some questions about what is important to you in the case. Okay? And we'll try to get you back to Nashville tonight. We're working on that. Okay?
Those are the alternates. The alternates get to go back to Nashville tonight. The rest of them will be here tomorrow for the aggravating factor, which the jury has to decide, which is decided separate from the guilt phase. And then the judge would provide sentencing, and there may be some. So we're back tomorrow for sure. What's happening is at 9 o'clock, the judge has another docket, whether it's arraignments, whether it's some other hearings. 9 o'clock, they have a few things to do. It sounds like defense wants till 10. So we're probably going to start right around 9, maybe have a little bit of court hopping while we wait for this case to start. And then once it starts, we'll jump over here and have the last of it. It means one more late night for this Aussie. Wow. Wow, wow, wow. Is this a death penalty case? No, it is not. It is not. The max they can get is life without parole is what I'm hearing. But the aggravation factor, no death penalty is what I heard. So, will they have impact statements tomorrow? Didn't hear it mentioned. They talked about it just briefly, about his parents possibly talking during that. And I'm not sure if that will happen tomorrow or at another point. Depends on the verdict. Melissa P., thank you. Hope you and Matthew are doing great. I feel like I'm floating, Sylvester. It's been wild. What a day. Can we play one more song for the jurors? Because I think they did a phenomenal job. This is the one I meant to play before, but let's see if we can play this one.
Listen close now, jurors, with your open minds. You'll face the facts and leave your doubts behind. In the court, you're called to see what's true and right. Through the twists and turns, you must bring light. Innocent or guilty, the choice is in your hand. You'll weigh the evidence and make a stand. No bias or favor, just the law and proof. In the hallowed hall, you'll seek the truth. Oh, the jury's called, duty to fulfill. Every word and witness through the quiet and thrill. Oh, the jury's called, guide us through the night. Find the justice waiting in the morning light. Oh, in your hearts let justice gently grow. Facts and reason guide the seeds you sow. Voices of the witnesses, memories of the scene. Through your wisdom, keep the verdict clean. Deliberation time will come, you'll take a seat. Discuss the trial's turn and who will face defeat. No
Okay, we're going to fade this one out here. Let me give you an update. I did lead you astray on how this was going to go, and let me tell you what I've found. Tennessee aggravating factors for first-degree murder include killing multiple people or using brutal methods. So they're going to get some limited testimony. It will probably be less than half an hour of testimony. Basically, just reminded them of what they saw. There might be a tiny bit new that wouldn't be allowed in as testimony during the guilt and innocence phase, but most of this will probably be rehashed from the original trial. These factors can increase the severity of the crime and potentially lead to the death penalty. Not sure if that's an option on this one anymore. Examples of aggravating factors would be killing multiple people. The murder involved killing more than one person, using brutal methods. The murder was committed using particularly brutal methods. That's definitely something that, I think the prosecution would be able to argue for. Killing a public safety official, that doesn't apply. Or previously convicted of murder, also doesn't apply. So I think we're going to hear the brutality of this attack as the sole aggravating factor. Other factors that may be considered are the context in which the murder occurred, the evidence of intent and premeditation, which there isn't a lot more of than what we already saw, and whether the defendant created a great risk of death to many people. So the brutality is probably going to be the focus tomorrow. This is not a death penalty case. They've said this all the while, but I don't think we can get back up to that. R.A. leads his neighbor astray. I did. I apologize for that. Wonder if the jury thought they were done and we're going home today. I think they did. My kids are having a blast playing a game in the other room. All right. With that said, I've got some stuff I need to take care of today for tomorrow's interview that I need to get squared away. I don't know why they didn't. I just know that they had the option and did not pursue that. Let's see. I'll only forgive you if we get to watch the rest tomorrow. We do. So sentencing is up to the jury. No, I believe the sentencing is up to the judge. The determination of an aggravating factor is up to the jury. What time tomorrow? It sounds like the court is going to begin at 9, but they're going to have other cases which will not be televised until about 10. So we're going to start probably about 9, and maybe watch something from some of the other courts that we normally watch that we've missed during this time. Are you kidding me? Just like that, I've got a spam call. Hello? 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 These are all my voices. Where's yours? Hello? I have to call back. All right. Told you it would be quick, says Sinbad. It was very quick. It was 47 minutes. Ari needs to work on his old lady's voice. I've actually debated getting a voice changer just for this purpose. It seems to be frivolous, and although I do buy a lot of equipment, as you can see, I love tech. A voice changer is quite frivolous for me. So, but maybe I'll have to get like a. Hey, I see you. Is that Mrs. R.A.? How are you doing? Do you have hot chocolate over there? You're drinking hot chocolate? Did you bring a mug with hot chocolate for me? No? No, she says no. No hot chocolate for me. All right. What do you say is our next trial? I didn't say there's one in West Virginia, Cochran trial, that we might have to play catch up on. I want to see how much more of that trial there is, if we can catch up, or what's going. But I've heard that's a good one. Was this ending an unexpected twist? Moni, I would say no. There was a preponderance of evidence and admission on the part of the defendant, as through his lawyers twice, that he was guilty. So a guilty sentence in and of itself was not a surprise. And as soon as we saw the defense attorney's story that he laid out as to how this happened not materialize in evidence, it pretty much became a done deal at that point. Let's see, you need to update the banner. That's me. I'm sorry, the mods don't do that. I will unpin the message. Jury is back. Yes, you missed it. We got a verdict. 47 minutes. Guilty as charged. The Cochran trial was here in my state, says Devents Moore. Is that West Virginia or Kentucky? I think it's West Virginia. I will pin this one. Thank you, Josh, for that. Josh, you are an amazing help. I really appreciate you, my friend. West Virginia. I think we all need some Stevens hot cocoa tonight. It's good stuff. The cheapest place I found it, I will give you the link if you want it on Amazon. And I admit I make some money if you do that. It's probably 20 cents per purchase. But the cheapest place you can find it is through Sam's Club. So if you know somebody who has a Sam's Club membership, you can buy it for like $12 for 4 pounds, which is the best price anywhere. It's like double that on Amazon. Online, Sam's online, because they'll ship it to you. And also you can ship it to other addresses. So if somebody else has a Sam's Club account, you can have them buy it for you and mail it to you at their price. Just pay them for it. Next trial, we're looking at the Cochran trial, but it depends how long it has left to go, and I haven't looked into that. Is it packets or a huge tub? It's a huge 4-pound canister. Off to watch. Barb, we may be headed there eventually, so we're gonna see this one through first. Have we ever seen Stevens hot cocoa at the store in Sam's Club?
Not here. They do have it at Walmart here, but
they've got the small, like the 1-pound ones at Walmart. You can find it. It's $12. It's literally half price if you can find online at Amazon or online at Sam's Club. Or I said he would buy it for me as a wedding gift. That's a good gift. It's a little cheap. I was going to do the Ferrari Testarossa, limited edition signed by, I don't know, whoever the guy is. But I guess I could go with the hot chocolate if you want, Josh. I could do that. We kid. All right, we are done. We're done for the day. It seems today's gone really fast. It's already 5:30 in the afternoon, and you missed the verdict music. Just rewind a little bit. It wasn't that long ago that we played it, and hopefully you can enjoy it that way. My Sam's Club membership went up to $100. I gave it up. Martha, for us with a large family, we buy a lot of food through Sam's Club, and for us it makes sense because the savings you get add up to more than the cost of our membership. So as long as that keeps happening and it keeps paying for itself, I think we'll keep it. But choice between Ferrari or hot chocolate. Cha-ching! Glug, 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 glug. Wait, what is the verdict? The verdict is that Jason Chen was found guilty as charged on first-degree murder as well as abuse of a corpse. No lesser included. The jury took 47 minutes of deliberation to reach that verdict, with juror number 15 reading quite clearly and confidently that was in fact the verdict. The defense did not ask for the jury to be polled. It's the first time I've seen that in a long time. And the alternates have been released. The jury, though, still sequestered, as tomorrow will come back. They're going to hear some more evidence to see whether or not they find that there is an aggravating factor that took place in this murder. It would be the brutality of it. I think that's the only way they can get that aggravation factor. That will weigh in on the penalty for sure. So we'll be back tomorrow about 9 o'clock, and the court should start by 10. It depends on how fast they finish things with their docket leading up to that. So, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning with what should be the last day of the Tennessee versus Jason Chen trial. You guys have a great evening. Be good to each other. We will see you in the morning. Bye-bye.